session over Deborah Nelson, Judge presiding.
Good morning. Please be seated. Good morning. We're on the record. Case number 12 CF 1083, State versus George Zimmerman. All parties are here and present. When I'm reading the jury instructions this morning, does the defense want me to include in that the right to remain silent? Okay. Was there anything else that we needed to take up before we bring the jury in?
This time we're moving to invoke the rule.
Okay. The rule of sequestration is being invoked. That means, are there any witnesses who are going to be testifying here in the courtroom? Okay. If you all want to go out and instruct your witnesses, you may do so at this time. Or
to the extent that the rule would ask that the defendant's family be excluded from that rule, they are somewhat maybe witnesses either called by the state or the defense. That would include father and mother. As you know, we have not, do not suggest that the victim's family be removed from the courtroom as they are witnesses, actually more substantive witnesses, but I would think that in fairness to both families that we would allow that.
Mr. D.
On the rule 90.616, the only witnesses that this rule does not apply to are the parents. I would cite 90.616, the parents of the victim. Specifically in a criminal case under 90.616 subparagraph D, in a criminal case, the victim of the crime, the victim's next of kin, the parent or guardian of a minor child, or the lawful representative of such persons, unless a motion by the court determines such person's presence to be prejudicial, she'll be allowed to remain in the courtroom. And so we would respectfully request that the victim's parents be allowed to be remain in the courtroom. We would object to anybody else being in the courtroom that's going to potentially be a witness.
Familiar with the rule, Your Honor. However, this court does have the discretion to allow other members of the defendant's family as well. And though the state is listed them as the witnesses and may well intend to call them, they shouldn't, by that maneuver, be allowed to exclude the defendant's family from the courtroom.
Well, they may come in after the state is finished with their case. Is there a reason why you feel that they need to be here in disregard of the rule of sequestration?
Yes. They are supporting their son in a second-degree murder charge and have the right to be here both for their own purposes.
Show me a case that says that, please.
Not prepared right now because this wasn't addressed pre-trial, Your Honor. So I would like some time to do that. Maybe while opening statements are ongoing, we'll get that for you. To the extent that that's going to occur, do you want them out at this point?
Yes.
Then Mr. Crump will also leave the courtroom?
Is he listed as a witness?
Yes, he is, Your Honor.
Yes, he will.
And any other witness you can identify.
Are there any other witnesses?
If that's the state's position, then the defendant's family should not be here.
Our position is we would just like the rule to be followed, and we've cited the rule.
Okay, and the rule says the victim's family. Everybody else must leave the courtroom until further notice of the court.
Also, Mr. Crump qualifies as the legal representative of the victim's family, so he should be allowed to remain in the court.
No, Your Honor, he's a very substantive witness in this case, and they have full representation here with the mother and the father. Should not extend this to a substantive witness.
I would point out, Your Honor, that as the court is well aware, Mr. Crump has been the subject of many motions. Throughout the proceedings, he has been available. In fact, last week he was available. The defense made a decision not to depose him at this time for tactical reasons or whatever, but which they have the right to do. But if it was such an urgent matter, they made a decision not to depose him.
Not certain of the relevance of that argument to the 616 exclusion of a witness that the state seems to be, again, still moving to enforce. I would, again, suggest a relaxation of it, but if the state does not want to go there and wants to follow the letter of it, I think that we should. And I would note that 616 is in the alternative. Either the victim's family or a legal representative, it does not say, and the intent of that is to allow for Mr. Martin's family to have representation, and they do. Mr. Crump, however, is going to be a very significant potential witness in this case. And if it's not going to be relaxed, it shouldn't be relaxed.
Okay, the rule specifically states, in a criminal case, the victim of the crime, the victim's next of kin, the parent or guardian of a minor child, or a lawful representative of such person, unless upon motion the court determines such person's presence to be prejudicial. So the state is asking for the rule to be invoked, or you asked for the rule to be invoked. The state asked for the rule to be invoked, and they're asking that Trayvon Martin's family or parents be allowed to remain, which is provided for, and they're asking for Mr. Crump to remain under what portion?
Under that same statute, Your Honor.
A representative?
Yes, Your Honor. He
Okay.
is the legal representative of Mr. Martin, the deceased.
And at this time, I don't have anything in this rule or any case law that says, of course, Mr. Zimmerman's family that's not on a witness list may sit throughout the trial. The issue is on the witness list.
If I might, Your Honor.
Yes, you might.
The 616 was never intended to suggest that the legal representative could be a substantive witness. The intent was to be certain that the victim's family under this statute is represented. They are well represented by mother and father. It was never an intent, and I would think it would be an absurd intent, and I'm about to file an oral motion to clear this up, that a substantive witness in the case would be able to slide in under the suggestion of a legal representation. So let me say it this way. I hereby move orally that it is prejudicial to allow a
Tell me
substantive...
the prejudice.
I'm about to, if I might. The prejudice is that Mr. Crump has continually committed or had press conferences where he has evidenced a strong representation, not only legally, but factually. It was 25 minutes ago that Mr. Crump had a press conference where he said there are only 2 facts that matter in this case to the public. I won't recite them to the court in case you didn't see it, but he very, very focused, suggesting his position factually, not just as a legal representative for this case. So as a factual witness, one, let's not forget, whom the Fifth District Court said is so substantive and has so few protections that we can take his deposition, is going to be a factual witness. He is a witness.
I don't recall them using the words that it's so substantive. I recall them saying, and I'm characterizing, that the deposition is extremely limited and should not take very long to accomplish.
Nonetheless, I don't want to argue with the point of what the Fifth District said. I understand your position. However, we have the right to depose him. That would, in my opinion, suggest that he is, in fact, a substantive witness. If he was
And
ministerial...
when did the 50CA opinion come out that told you you had the right to depose him?
A month
ago, and you
Yeah.
haven't deposed him yet.
And I think the court is well aware why.
Well,
If need be, I will tell you what I've done for the past 30 days, getting ready for this case to try today. But the reality is, the fact that we've decided to wait until this week to take his deposition does not suggest that he's less than substantive, does not suggest that he's a legal representative that should slide under 9616 when the family is otherwise fully represented.
the court made note last week when you had brought up about the depots that Mr. Crump had sat in this courtroom the entire time of jury selection, and that he was here and available, and you could have used the court reporter and this courtroom to accomplish that deposition any evening or at any time. So it was not his availability. But I don't want to get into that right now. I'm going to ask Mr. Crump and the defendant's family that are under subpoena to please leave the courtroom. We will get the case law over lunch, and the court will review the case law and make a final decision. I'd like to get on with closing arguments, and that's why I'm asking that to be done at this time. I don't know, I see that Mr. Crump is here. I don't know if there's any member of the Mr. Zimmerman's family that's here that's under subpoena. Okay, if they are, please inform your witnesses that the rule of sequestration has been invoked. Anything else we need to take up before we bring the jury in to start with instructions? Yes, sir.
Police court, I did this morning file a motion due to the fact that came up during the deposition on Saturday over the weekend. It simply relates to, apparently there is a exhibit prepared by a witness who was provided for deposition on Saturday. That exhibit is, as far as I know, still yet unviewed. But if there's going to be no mention of it in opening statement, obviously the state is fine with deferring consideration of the motion for you. If there's going to be a mention of this, and it's specifically witness Shoemaker and a recreation, then I think we would prefer to have that addressed now.
Well, I just walked on the bench, and it's sitting up there. I have not looked at it. It has not been provided to me before now. Mr. O'Mara, were you intending to mention this in opening statement?
The animation itself, Your Honor, not specifically, but I will tell you that there is a demonstrative evidence aside from that which the state has been provided, not the animation, but literally what we call a poster, which is a scene, you might call it a snapshot from the animation. So,
Is there any objection to that demonstrative?
I would like to see it first. Which
we'll
one?
tell them
Because
which one it is. We sent them all 10, but I'll point out which one.
Could you please do so now, because we're getting ready to go into opening statements. Thank you. Okay. There's no objection to that? Okay, that's great. Anything else? Who's going to be doing the opening for the state?
No, I will.
Mr. Guy, and for the defense? Mr. West, okay, thank you.
We do have another matter, though. We touched on it last Friday. It has to do with the raised geste statements. There was some question precisely what they were. I had raised the issue back in late May when we had the hearing on the state's sort of generic motion to exclude hearsay of the defendant. And has the court received the motion?
I received something that's on my desk, but I was working on the Fry hearing order. So at the time that I received it, I was right in the middle of doing that. So I have not read it.
Well, Your Honor, I have a copy that the court may have now, of course. This is very important evidence, and that the court, I think...
Can I ask you, sorry to interrupt, but can I ask you, are you going to be mentioning any of that in opening?
Yes.
Well, then we need to have a hearing on this. Let me have the motion.
Thank you, Judge. This is an unsigned copy.
That's fine. Thank you, Susan.
May we request a copy of the motion?
Another copy?
None was given.
The state was not given a motion, the copy of the motion?
When was it provided?
The document that I went on Friday, but I'll get you the copy.
We have not received any motion.
Okay.
I know you spoke about it Friday, you're right, but.
This is unsigned.
Sure, that's fine.
Okay, has the state read the motion?
We have no.
Okay, is the state familiar with 90.8031?
Yes, Your Honor.
Okay, and the defense is also? Because there are a couple of statements here, and two of which I find would fall within that, the third of which may not. I don't know how much time expired between the event and the police officer arriving, and I would have to know what that time frame was. Is there any response by the state as to those three statements?
Regarding, to answer the court's question first, it was within minutes of the shooting in terms of when the officer responded and also when he made statements to, at least one of the statements alleged to witness number 13, whose name will become known. I will point out that witness number 13 in his deposition, when he was asked regarding the statements, he stated that the defendant was calm. So I don't know that it rises to the level of excited utterance. He did make those statements.
Well, it says a spontaneous statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter, except when such statement is made under circumstances that indicate its lack of trustworthiness. If more than a slight lapse of time has occurred between the event and the statement, the spontaneity is lacking. The statements to witness 13, I think, would fall within that. I don't know as to the law enforcement officer, so I will reserve as to that one, but the other two.
I can help with the timing. It was very, very fast. As the motion indicates, Officer Smith was already en route because Mr. Zimmerman had told the dispatcher to please send an officer. So he was always there. I think it's less than a minute, and he, witness 13 and Mr. Zimmerman were standing there when Officer Smith walked right up to them. So, in fact, Officer Smith said at his deposition that Mr. Zimmerman spontaneously said, "I was yelling for help and no one would help." So it's very close in time. It's not a question really of the actual number of seconds in any event. It's really the circumstances, and the trustworthiness comes from the circumstances themselves, not a precise measure of the time, keeping in mind that Mr. Zimmerman was bleeding from the face and from the back of his head. He was out of breath and had been staggering, and witness 13 described him as someone who had just gotten his butt beat. Within seconds of that encounter, Officer Smith came up, and Mr. Zimmerman was handcuffed for the officer's safety and said,
Okay.
I was...
I
have the Stiles case, which quotes extensively from the Alexander case. Both of those cases were cited by the state in its original motion in limine, but they are squarely on point with my issue here.
Okay. What I'm reading here is that while there is no requirement under the spontaneous statement exception that the statement being made while the declarant is in an excited state, in order for a section 90.8032 exception to be present, the declarant must be excited. Under section 90.8031, spontaneity and contemporaneity are key rather than an excited state of mind, so I will let them in. Any other matters that?
One final
Yes.
housekeeping matter. I just wanted to introduce to the court Sarah Waldrop. She's a trial paralegal and will be assisting us throughout the case.
Thank you very much.
Not been in court.
And welcome. Anything else we have to do to? We're ready for the jury. Let's go ahead and bring them in. Oh, I know. If counsel would please approach for one brief moment. Welcome back, and I'll be with you in just one moment. Okay, be with you in just one moment. As the rules of sequestration have been invoked, that means to any potential witnesses that they're not to listen to any portion of the trial, whether they be at home or here at the courthouse, that they're not to discuss their testimony that they will be giving during this trial to anybody other than the attorneys if they request a meeting for them. They're not to allow anybody to tell them what is going on during the course of the trial. And I hope, good morning, ladies and gentlemen, and I hope that you're all well settled in, and I welcome you back to court. Before we get started today, I'm going to ask you certain questions, and if your answer is yes to any of my questions, please raise your hand. During the recess overnight, did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or events? No hands are being raised. Did any of you have any conversations with each other or with anybody else about this case? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? Okay. You were previously sworn. You were selected and sworn as the jury to try the case of the state of Florida versus George Zimmerman. This is a criminal case, and George Zimmerman is charged with murder in the second degree. The definition of the elements of the crime charged will be explained to you later. It is your solemn responsibility to determine if the state of Florida has proved its accusations beyond a reasonable doubt against George Zimmerman. Your verdict must be based solely on the evidence or lack of evidence and the law that I will give you. The information, which is a charging document that I read to you on Thursday, is not evidence, and you are not to consider it as proof of guilt. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of the case may be and to apply the law to the facts as you find them. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it would be helpful if you understood how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys an opportunity to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their final argument. Following the arguments by the attorneys, the court will instruct you on the law that is applicable to this case. After the instructions are given, you will then retire to consider your verdict. You should not form any fixed or definite opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instruction on the law that I will give you. Until that time, you should not discuss the case among yourselves. During the course of the trial, when we take recesses, and you will be separated from the courtroom and go about the sequestration rules. And during these recesses, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you are on the jury and trying the case, and ask them to stop. If they persist, leave them at once and immediately report it to one of the court deputies. The case must be tried by you only on the evidence presented during the trial in your presence, in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in the case. This applies whether you are in the courthouse, during your sequestration, or anywhere else. You must not visit any of the places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have any discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask you questions about the trial. In this age of electronic communication, I want to stress this again, that just as you may not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they deem proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you don't want to. That will be left up to you individually. You have been provided with a notepad and a pen for your use if you wish to take notes. Any notes you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the deputy will take possession of your notes and will return them to you when we reconvene. After you have completed with your deliberations, the deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, don't get so involved in the note-taking process that you become distracted from the proceedings. Your notes should only be used as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. At this time, we'll begin with our opening statements. Mr. Guy, you may proceed.
May it please the court, counsel. Good morning. Fucking punks. These assholes, they always get away. Those were the words in that grown man's mouth as he followed in the dark a 17-year-old boy who he didn't know. And excuse my language, but those were his words, not mine. Fucking punks. These assholes, they always get away. Those were the words in that man's chest when he got out of his car, armed with a fully loaded semi-automatic pistol and 2 flashlights, to follow on foot Trayvon Benjamin Martin, who was walking home from a 7-Eleven, armed with 23 ounces of Arizona brand fruit juice and a small bag of Skittles candies. Fucking punks. These assholes, they always get away. Those were the words in that defendant's head just moments before he pressed that pistol into Trayvon Martin's chest and pulled the trigger. And then, as the smoke and the smell of that fatal gunshot rose into a rainy Sunday Sanford night, Trayvon Martin, 21 days removed from his 16th year, was face down in wet grass, laboring through his final breaths on this earth. And that defendant, at that same time, was upright, walking around, preparing to tell law enforcement why it was he had just profiled, followed, and murdered an unarmed teenager. Ladies and gentlemen, the truth about the murder of Trayvon Martin is going to come directly from his mouth. From those hate-filled words that he used to describe a perfect stranger, and from the lies that he told to the police to try to justify his actions. If you'll indulge me for the next few minutes, I would like to share with you in a little greater detail the end of Trayvon Martin's young life and the overwhelming evidence of this defendant's guilt. The murder of Trayvon Martin was the product of 2 worlds colliding. In one world, a 17-year-old boy from Miami, Florida, a visitor to this town, who had gone to the store to get something to drink for himself and some candy for a 12-year-old friend. But in the other world, a 28-year-old grown man, somebody who wanted to be a police officer, somebody who had called the police numerous times about crime in his neighborhood, someone who had become the neighborhood watch captain, and someone who believed, most importantly, that it was his right to rid his neighborhood of anyone that he believed didn't belong. The date was February 26th of last year. Trayvon Martin was in town with his father, Tracy Martin, and they were visiting Tracy Martin's girlfriend, Brandy Green, and her 12-year-old son, Chad Joseph. They lived together in a townhome in a gated complex known as the Retreat at Twin Lakes. And on that day, Trayvon Martin spent the day with 12-year-old Chad Joseph doing what kids do. They watch TV. They play video games. They just hung out. But in the afternoon hours, in the early evening, Trayvon Martin decided to go to the store to get something to drink. And he asked Chad Joseph, "Do you want anything?" "Skittles," was the reply. And so Trayvon Martin set out on foot by himself and walked just less than a mile to a nearby 7-Eleven. You'll see his purchase of those two items, a 23-ounce can of Arizona brand fruit juice and Skittles, on a 7-Eleven surveillance video. And at 6:24 p.m., he walked out the door. And he started walking home in the rain. And although he was by himself, he wasn't entirely alone, because he spent that walk home on the phone with a young friend from Miami, Rachel Gentel. And as teenagers are wont to do, he talked to that girl the entire way home. But at that same time, when he got into the neighborhood of the Retreat at Twin Lakes, there was this defendant riding around in his car, not with candy, not with fruit juice, but with a Kel-Tec 9mm semi-automatic pistol in a ready-to-fire position, meaning there was one live round in the chamber. And that firearm was tucked inside his waistband. And although that defendant was alone, he too was not by himself, because he picked up the phone and he called the Sanford Police Department. Because when he saw Trayvon Martin, he didn't see a young man walking home. As he told the dispatcher, Sean Nofke, he saw someone that was real suspicious. Somebody that looked like they were up to no good. Again, his words, and you'll hear that tape. It was recorded forever. And you'll hear how he describes Trayvon Martin and how he follows him. And how he says, not in response to a question, "These assholes, they always get away." And he tells Sean Nofke, "There's been a bunch of recent burglaries in my neighborhood." And you'll hear the door chime in his car when he gets out with his gun, and not one, but two flashlights to follow Trayvon Martin. And then, almost under his breath, that defendant will reveal to you his feelings about Trayvon Martin when he refers to him as a fucking punk, this 17-year-old boy walking home. And then right at the end of that phone call, this defendant makes the decision that brings all of us here today. Sean Nofke asked the defendant, "Shall I have the officer who's on his way meet you at the mailboxes?" Because the defendant and he had discussed a kiosk of mailboxes that are in that neighborhood. And at first the defendant says yes. And then he changes his mind. "Tell the officer to just call me, and I'll tell him where I am." Because George Zimmerman was not going back to the mailboxes. And he wasn't going back to his car. He was going after Trayvon Martin. Less than 4 minutes after that defendant hung up with Sean Nofke, Rachel Gentel, that girl in Miami, heard Trayvon Martin say, "What are you following me for?" And then Trayvon Martin's phone went dead. And Trayvon Martin went dead. The first two officers to Trayvon Martin's body found him exactly like that defendant left it. Face down, his hands clutching his chest. He was dressed in white tennis shoes, long khaki pants, a dark gray hooded sweatshirt. He had a plastic dark gray watch on his left wrist. The little earbuds that he was using to talk to Rachel Gentile on the phone were right next to his head. And his phone was right next to his body. And Sergeant Raimondo will explain to you the steps that he took to save Trayvon Martin's life. And he'll admit to you, he didn't exactly follow SOPs with the police department, because they hold that if you are to try to give mouth to somebody, that you go to your car first and you get a breathing mask to separate your mouth from their mouth. Well, Sergeant Raimondo realized there was no time for that. So he put his lips on Trayvon Martin's lips and tried to breathe life into him. And Officer Ayala put his palms on Trayvon Martin's chest and tried to push life into him. But it was too late. Trayvon Martin had already passed. Rescue responded soon after, and they took over the CPR efforts, and they hooked up a cardiac monitor to Trayvon Martin. It was a flat line. He had already died. And so Sergeant Raimondo then went to his car, and he got a yellow medical blanket, and he put it over Trayvon Martin's body. And they took the drink can that he had in the center pocket of his sweatshirt, and they put that on top of the blanket. You also hear from the first officer that had contact with this defendant. He was walking around, able to walk, talk, balance, answer questions, understand questions. He had a bloody, swollen nose, and he had 2 lacerations on the back of his head. And you'll hear from the rescue personnel that treated the defendant at the scene. They wiped the blood from his nose, and they wiped the blood from the back of his head. And then the defendant was asked, "Do you want to go to the hospital?" "No," was the defendant's response. And so they took him downtown. And you'll see exactly how he appeared, because when he got downtown to the police station, they took over 30 photographs of him, head to toe, front and back. You'll see exactly how he looked that night. Exactly. And you'll see videos of him walking through the police station, getting out of the car. And then he goes to that interview room where all of his statements would be recorded for you. That night, the next day, even a walkthrough the next day where they literally got a video camera and let him explain in his own words what had happened. And he did. And you will learn that that's when he began to spin that tangled web of lies. For example, he told the police that it was just after he hung up with Sean Nofke, the non-emergency dispatcher, that Trayvon Martin approached him, confronted him, said a couple of words to him, and then punched him and knocked him to the ground. Just moments after that. Ladies and gentlemen, that did not happen. You will have phone records. Phone records from his call and phone records from Trayvon Martin's call. The defendant hung up the phone with Sean Nofke at 7:13 p.m. and 43 seconds. But Trayvon Martin, who was on the phone with that girl from Miami, His call didn't end until 7:15 and 44 seconds. 2 minutes later. 2 minutes that defendant was not going back to his car. He wasn't walking towards the mailboxes. He was walking after Trayvon Martin. For example, the defendant told the police that at one point while he was sitting in his car following Trayvon Martin ran behind some townhomes and then came back out, circled his car, and then ran back again. Listen to the non-emergency call that happened in real time, and you'll see that that didn't happen. It's physically impossible the way he described it. For example, he told the police that the reason he got out of the car was because Sean Nofke told him, "We need an address." That didn't happen. Listen to his non-emergency call. Sean Nofke never said that. For example, he said that Trayvon Martin had him down on the ground, was straddled over top of him, and took his hands and covered his mouth and his nose. His nose that was bleeding already from having been struck by the first punch. Well, they looked at Trayvon Martin's hands. There was no blood on them. They took wooden sticks and they scraped his fingernails. Trayvon Martin's. No blood of George Zimmerman. No DNA of George Zimmerman. They examined the cuffs of his sweatshirts. He had two on, two long sleeve sweatshirts. They examined the cuffs and the sleeves. No blood of George Zimmerman. No DNA of that defendant. The only blood of George Zimmerman was on the waistband of one of Trayvon Martin's shirts. But the Trayvon Martin's blood was on the defendant's clothes. For example, the defendant claims that while Trayvon Martin was on top of him, Trayvon Martin said to him, "You're going to die tonight." Well, ladies and gentlemen, you're going to hear from people who were out there. Nobody heard that. For example, he said that after he shot Trayvon Martin, he got on top of Trayvon Martin on his back, and he took his arms and he spread them out. That didn't happen. You're going to see the pictures of Trayvon Martin by a civilian who went out there that night before the police got there and snapped off a photo on his phone. Trayvon Martin's hands are underneath his chest. Listen carefully to his statements. And you won't just have his statements and those phone records. You'll have physical evidence. Irrefutable physical evidence. Like the DNA evidence of Anthony Gorgone with the Florida Department of Law Enforcement. He was the one who examined the sweatshirts and didn't find any of the defendant's blood on Trayvon Martin's cuffs or sleeves. And he was the one who examined those little wooden sticks and didn't find any of the defendant's blood or DNA on those either. He also examined swabs taken from the defendant's gun and that holster that he had inside his waistband, because the defendant claimed that Trayvon Martin saw his gun and went for his gun, so they tested it. Well, guess what? Trayvon Martin's DNA is not on that gun. Trayvon Martin's DNA is not on that holster. And you'll hear from a firearms expert also with the Florida Department of Law Enforcement, Amy Seward, who will tell and show you all about that firearm. Kel-Tec 9mm pistol. Holds 7 rounds in the magazine that loads from the bottom. But she'll tell you at the time it was fired, there were 8 rounds in the gun because there was a live round already in the chamber. So it wasn't necessary for the defendant to rack it to load a round. It was ready to go. And you'll learn that although this firearm doesn't have an external safety mechanism, it has what they call an extra long trigger travel distance, which is just what it sounds like. Person has to depress the trigger a longer distance to ensure that there are no accidental discharges. And Amy Seward did distance testing to determine the distance between the muzzle of the gun, that is the end of the barrel, and Trayvon Martin's clothing when he was shot. The distance was 0. It was a contact shot. He pressed that gun into Trayvon Martin's chest, and you will see with your own eyes the burn marks on each of his sweatshirts where that hot lead passed through. You'll also have the evidence from the scene. And the first thing you'll learn about that scene is how remarkably dark it was. Trayvon Martin was murdered in the back of 2 sets of townhomes. There's no street lighting back there. There's no pole lights. There were 1 or 2 porch lights on, but you'll see how very dim they are and how remarkably dark it was, and that it was raining. And they will give you, Diana Smith, the crime scene technician, will give you all of the physical evidence there. Trayvon Martin's cell phone, the headphones, the defendant's big black flashlight that was right by Trayvon Martin's body, his little flashlight on a keychain that was some 30 feet away, a bag that Sergeant Raimondo used, because when they started doing CPR, Sergeant Raimondo heard air seeping from Trayvon Martin's chest. And he called for someone to bring him some kind of plastic, and they brought him a white Walmart bag. And they held that on his chest to keep the air in while they were doing CPR. You'll have the drink can, the Skittles from the pocket of his sweatshirt, the shell casing that was right near his body was also collected. And you won't just have the physical evidence at the scene. You'll have the testimony of people who were there, residents. And they too will tell you how dark it was out there. And the other thing that they will share with you is that no one heard or saw this from beginning to end. All of them who were witnesses got slices, if you will, of what happened. Some at the beginning, some in the middle, and some at the end, just like you would expect with real life on a rainy Sunday night. But you'll learn that those witnesses too contradict the defendant's story about what happened, because he described a very short verbal exchange between the two of them. But the witnesses will tell you they heard a longer verbal exchange that went on for some time. And the defendant said he was knocked down by the first punch and Trayvon Martin got on top of him. But I expect you'll hear from a witness who says she saw them upright, struggling. And you'll learn that Trayvon Martin's body, again, is some 30 feet away from where the defendant claims he was first knocked down. And nobody heard Trayvon Martin say anything about the defendant that he was going to die tonight. You will hear from a witness who came outside of his residence during the middle of it. And he will tell you that he thought at first it was some people, kids playing, but then when he got outside, he realized it was something more serious. And he told him to stop. And he saw one person, who was Trayvon Martin, on top of this defendant. He was looking at Trayvon Martin's back. And he'll tell you that he saw his hands on the defendant's body. But he didn't see arms flailing. He didn't hear flesh meeting flesh. He didn't see or hear the defendant's head being slammed into concrete like the defendant claimed. He didn't hear or see any of that. And then he too saw his small part and went inside. Ladies and gentlemen, you're also going to hear from a physician's assistant named Lindsay Fulgate, who examined this defendant the very next morning at 11:15 a.m. when he walked into her office. For this reason, he told her he needed a note for work so he could go back to work. He didn't complain of so much as a headache, no dizziness, no vomiting, no nausea. He said he needed a note for work, but she examined him. And she examined his nose and thought that it possibly could be broken. But then she looked at it with her instruments, and everything was perfectly in line. He didn't have so much as a deviated septum. And she looked at the injuries on the back of his head. She measured them. The longest one was 2 centimeters. That's about 3/4 of an inch. Neither of the 2 lacerations needed a single suture. Also in this case, in addition to the witnesses, you will have a bone-chilling 911 call, where in the background you will hear the gunshot that killed Trayvon Martin. And you will hear screaming in the background. Listen carefully, please, to that call. And listen carefully when the screaming stops. It's right when the gunshot goes off. Trayvon Martin was silenced immediately when the bullet that the defendant fired passed through his heart. And when that gunshot rings out on that 911 call, the screaming stops immediately. Listen carefully to that. Ladies and gentlemen, also in this case, you will learn about the person riding around in the car that night with the gun. That this defendant wanted to be a police officer, had applied to go on a police ride-along, was a criminal justice major, took classes in the law of self-defense and crimes in the state of Florida, studied them. You'll learn that he became a neighborhood watch coordinator because he reached out, the defendant, to the Sanford Police Department and a woman named Wendy Dorval and asked her to come to his community, and she did. And she gave a presentation about the do's and don'ts of neighborhood watch, and it's just like it sounds. See and report. Observe and call. He was told, do not be the vigilante police. Don't follow. Don't confront. Just call and observe. And you'll see the actual materials that he was provided. And you'll learn that he was appointed the neighborhood watch coordinator because of all the crimes in his neighborhood. which is why when he first saw Trayvon Martin, he didn't see a kid from Miami walking home from the 7-Eleven. He profiled him as someone who was about to commit a crime in his neighborhood. And then he acted on it. And that's why we're here. And you'll learn about him physically. He wasn't nearly as large as he is now. He was just over 200 pounds. He stands 5'7.5". But at that time, back in February of 2012, he had been taking classes from a gym for a year and a half. Not any gym. Not Bailey's. But a gym where they teach you to fight. Kickboxing. Mixed martial arts. Self-defense. For a year and a half. That's what he was doing before February 26th of last year. And finally, ladies and gentlemen, you'll hear from the medical examiner, Dr. Shipping Bao. You'll learn that Trayvon Martin arrived for his appointment with Dr. Bao, dressed in the same clothes that he was wearing when he walked out of the 7-Eleven. And in a sky blue, heavy plastic body bag that had a little lock on it, fastening together the two zippers. And the first thing you'll learn when you see Trayvon Martin's body stretched out on the medical examiner's table is how thin he was. He was 5'11", 158 pounds. 158 pounds. How remarkably thin he was. And they examined Trayvon Martin's body. In his hands, he didn't have bruised knuckles. He didn't have swollen hands. The only injury to his hand that was capable of being photographed was a small abrasion on his left ring finger. Trayvon Martin was right-handed. That was the only injuries to his hands. And Dr. Bao will take you through the fatal gunshot. And just like the shirts, you'll see burn marks on Trayvon Martin's chest. Just to the left of center, you'll see the little stipples, they call them, stippling, little pinpricks in his skin where the bullet entered. And Dr. Bao will take you through the path of that bullet. It wasn't to the left, it wasn't to the right, it wasn't up, it wasn't down. Straight through his body, right through his heart, right where the defendant put it. And ladies and gentlemen, that is just some of the evidence in this case. And at the end of this trial, Judge Nelson will read to you the law that applies to all of us, and a law that applies to each of us. And we are confident that at the end of this trial, you will know in your head, in your heart, in your stomach, that George Zimmerman did not shoot Trayvon Martin because he had to. He shot him for the worst of all reasons, because he wanted to. Thank you for your time.
Thank you, Mr. Guy. Mr. West, you may proceed.
Thank you. We're going to need a few minutes. We have some demonstrative pieces that we'd like to bring into the courtroom and need to set up the audio-visual equipment.
How long is it that you think you need?
Oh, probably 15 minutes, 20 minutes.
Okay, we'll take a 15-minute recess. Ladies and gentlemen, please put your notepads face down and follow Deputy Jarvis. Please be seated. Back on the record. You wanted to approach?
Pretty much very quickly on.
Okay, are you all set up? Is the defense ready?
Yes.
Okay, let's go ahead and bring the jurors back in.
Jurors present, Your Honor.
Please be seated. The record will reflect the presence of the jury. Mr. West, you may proceed.
This is a sad case, of course. As one of your fellow jurors commented during the jury selection process, a young man lost his life, another is fighting for his. There are no winners here. How profound and how insightful. Sabrina Fulton and Tracy Martin are grieving parents. Without question, they have the right to grieve. They have the right to feel the way they feel. George Zimmerman's parents also are grieving. You see Trayvon Martin's parents, Mr. Martin and Ms. Fulton, here in the courtroom. They're seated right over here. They're likely to be witnesses in the case. You don't see Mr. Zimmerman's parents here, though. They would be seated over here the way the courtroom has been constructed. And there's a reason for that. The reason is that they are on the witness list. They may testify, they may not. As you know from the beginning of this, there's a couple of hundred people on there, and certainly not all of them will testify. But because they might, and because they are not related to the deceased, then they're not allowed in the courtroom now. That's the reason. Not that they aren't here, not that they aren't, in fact, right around the corner in a room wishing they could be. That includes Mr. Zimmerman's wife, Shelley, and other family members. Any witnesses, unless there's a specific exclusion that they may sit in the courtroom, cannot. I grew up in a family that had certainly moments of great joy and moments of profound sadness. There's no doubt all of us have had in one form or another. And my mother used to, actually, she still says, if she gets a chance.
Objection, Your Honor, as to improper argument during opening statements.
Sustained. It's personalizing. It's supposed to be what the evidence will show.
Well, I think the evidence will show that this is a sad case, that there are no monsters here. Sometimes you have to laugh to keep from crying. So let me, at considerable risk, let me say, I'd like to tell you a little joke. I know how that may sound a bit weird in this context under these circumstances. But I think you're the perfect audience for it. As long as you if you don't like it or you don't think it's funny or inappropriate, that you don't hold it against Mr. Zimmerman. You can hold it against me if you want, but not Mr. Zimmerman. I have your assurance you won't. Here's how it goes. Knock, knock. Who's there? George Zimmerman. George Zimmerman, who? All right, good. You're on the jury. Nothing? That's funny. After what you folks have been through the last 2 or 3 weeks? Let's get on to, however, the serious business of why we're here. Let's take a look at where all of this started. George Zimmerman is not guilty of murder. He shot Trayvon Martin in self-defense after being viciously attacked. And here's the evidence that will show you how and why it happened the way it did. I've got some things to display for you that will help. Some of them will be up there too. Is this okay? All right. I'm sorry. Okay, what you're looking at is an aerial view of the complex in Sanford. It's over near the Seminole Town Center there, called Retreat at Twin Lakes. This is basically the whole thing. Just as a bit of orientation, George Zimmerman lived down here in this area. This street is called Retreat View Circle. Sometimes people use that interchangeably with the complex name. The complex is Retreat at Twin Lakes. This is Retreat View Circle. Here is the clubhouse. You can see the pool right here. This is considered the main entrance. And this is known as the back entrance. So we have the main entrance here, there's a gate, and the back entrance here. I guess you can get in either way, of course. The pool, there's some mailboxes around here for the community. And I think this is called Twin Lakes or Twin Trees, this street that cuts through here. You'll hear a lot of testimony about the T intersection, the T. That simply is where two sidewalks connect perpendicularly. That's where almost all of the important events took place, within just a few feet of that. Let me point that out to you here, and we have a better picture to focus. This is it. Sometimes this is called the dog path or the dog walk, and there's the T right here. You can see over here is, again, Retreat View Circle, and this can be a cut through. So you can, if you're walking, come right through here between these rows of houses, go down this way if you want to get to this area, or continue on through if you want to get to Retreat View Circle. These are the backs of the houses. The fronts facing the street, the backs. They all have patios. They're all basically the same floor plan townhomes. They have patios. Some of them have screened-in porches. Some don't. This is the back of this row of houses here. So, as George Zimmerman left his house in his Honda Ridgeline truck to go to Target to get some groceries for his lunches for work. This was a Sunday night, February 26, 2012, in the neighborhood of 7 o'clock. In fact, just a few minutes after 7. George Zimmerman leaves his house in his truck and goes out here to get to the exit on his way to Target. He sees a person that later becomes known, of course, as Trayvon Martin, coming into the community, not through the gate, but cutting through the houses, standing in a place where people that live there wouldn't typically come into the community. There's a big, let me show you. Some of these turned out better than others. Just to get sort of oriented a bit. You may have some difficulty. Reinhardt Road. The complex right here is over here. The main entrance is off here, the back entrance over here. This is a big apartment complex. I think it's called Colonial Villages. Over here is the 7-Eleven. That's where Trayvon Martin went to buy the snacks. So to get from here to here, you can come this way and up, or you can cut through this path that cuts off sort of the triangle and go up here. About a mile. I know that's hard to see. It's about a mile from here to here. You can also cut through these apartments if you want to save a little distance. You can cut through these apartments and just go right through the gully up into the complex over in here. You can see part of the other complex here. So George Zimmerman sees Trayvon Martin in a spot and he caught his attention, caught George Zimmerman's attention. Little did George Zimmerman know at the time that in less than 10 minutes from him first seeing Trayvon Martin, that George Zimmerman, would be sucker punched in the face, have his head pounded on concrete, and wind up shooting and tragically killing Trayvon Martin. George Zimmerman participated in Neighborhood Watch. The community asked him to do that, to be the liaison with the Sanford Police Department. Wendy Dorval is the person with Sanford that coordinates all of that. She comes out to homeowners upon requests and gives a presentation, PowerPoints, literature. She wants a point person, if you will. Not a captain, a liaison, someone they can email, someone that can help distribute the flyers that she prepares, and to coordinate the Neighborhood Watch effort in the community. Ms. Dorval knew there was increased crime activity in this particular community over the several months prior to this event. There had been a number of burglaries. She can tell by crime mapping that crime was on the rise, that people were stealing things. There had even been a home invasion, and that the homeowners association was interested in forming a Neighborhood Watch. This is late summer, early fall of 2011. George Zimmerman had been active in the community and was asked to help coordinate that. So he did. There's some emails back and forth and such. No patrols were set up. George Zimmerman wasn't patrolling this night or any other night. But people were told if they see something suspicious to phone it in. Call the police. If you think there's a crime taking place, you call 911. If you don't necessarily think there's a crime taking place, but since you are the ears and the eyes of the community and you want to bring the person or the event to the attention of law enforcement, you have a separate number. That's the non-emergency number that you've heard about. It was recorded, and we're going to play it here in just a few minutes. George Zimmerman called the non-emergency number and described for the dispatcher, a fellow by the name of Sean Nofke, what he was seeing as he was seeing it. Mr. Nofke was asking questions. Mr. Zimmerman was giving answers. You will hear the tone of voice. You will hear both sides of the conversation. You will hear those words, "These assholes always get away," "fucking punks." You'll hear those words, and I hope that you'll put them in the context in which they were said and assign whatever meaning ultimately you think they have, if any, in the overall context of this. So what we did, let me draw your attention to something before we actually play the recording. There's been a lot of publicity, some of you may have even heard it, that George Zimmerman was in his car and was told not to follow Trayvon Martin, and he did anyway. That is absolutely untrue. Absolutely untrue. And you will hear that on the call we're going to play. You'll hear the conversation. You'll hear, as Mr. Guy pointed out, the chime. You can hear Mr. Zimmerman opening the door. You can hear the door shut, if I'm not mistaken. And you will know on our timeline exactly when that happened in reference to everything else. You'll know when George Zimmerman got out of the car, and you'll know what he was doing when the call ended. But there's something else, though, to keep in mind, because we put a little timeline together that shows the sequence of events on the non-emergency call. But we also connected up the call from a woman named Rachel Gentile. Rachel Gentile is a person that has been variously described as Trayvon Martin's girlfriend. She was clearly a friend, although not a girlfriend, but they had been communicating pretty regularly on the phone and by text for a couple of weeks. And that Trayvon Martin had spent a lot of time on the phone with her this particular day and the days preceding it while he was up in Sanford. So that calls, actually. There was a call that started before Mr. Zimmerman's non-emergency call and then ended at a point that we'll show you. And then there was a gap of about 20 seconds, more or less, where the call with Ms. Gentile ended, and then it started up again at about 7:12 and some change. So there's only about 20 seconds there. However, George Zimmerman is still on the phone with the police during that gap. And then the call reconnects, and it's a continuous call between Trayvon Martin and Ms. Gentile until 7:15:43, roughly. We'll connect that with the first call to 911 made by the resident who lives right here. The times are written on the timeline, so I won't bother trying to remember them and get it wrong. But that was at about 7:16:11, roughly. And the call between Rachel Gentile and Trayvon Martin ended about 7:15:43. So it's around 30 seconds from when the call ended. Of course, Mr. Zimmerman is not on the phone at this point. Mr. Martin and Ms. Gentile are. And then the call from the resident, having heard the commotion. Here, I'm sorry if I didn't say that before. Let me show you. Okay. This is the T again, right here, and here. Now we are over here. This is the T. The angle is a bit bad, so it looks like this house obscures it. It doesn't. There's an equal distance through here, and we can show you that. So this is the person who lives right here who calls 911 after hearing the commotion that starts right here. And best guess, 20 to 30 seconds after the commotion started that caught Ms. Lauer and her husband, Jeremy Weinberg's attention. And by the time they got the phone figured out and working, got connected with 911, about 30 seconds roughly had passed. And then that's the call that you'll hear the rest of. Now, you'll hear the screams in the background. You'll hear the shot. We'll play that here, too. And you'll hear, of course, Ms. Lauer talking to Sean Nofke. I'm sorry, not Sean Nofke. He was the dispatcher speaking with Mr. Zimmerman. I don't know who Ms. Lauer was talking with on her call. Again, this is the clubhouse, the pool, and you'll hear testimony that George Zimmerman's truck, this silver Honda Ridgeline, was parked right about here. It was seen later that night after the shooting by another Retreat at Twin Lakes resident and neighbor of Mr. Zimmerman, a woman by the name of Eloise Dilligard. She saw his truck and said, that's George's truck. I'll ask him what's going on. We'll talk more about that in a minute. So this is just another view. If you see them side by side, this is the T. There's a little doggy disposal station here. Jonathan Manalo lives on the end. Jenna Lauer and Jeremy Weinberg live here. And right next to them is John Good. He was the eyewitness. He's really the only resident that actually saw much of anything close in time to the shot. And he got a good look. He made a diagram, in fact, of what he saw that night. I'll show you that. He gave a clear description of what he saw, and we'll talk more about that later. So, before I'm done today, I also want to spend some time talking with you about the forensic evidence that's directly connected with the shooting. But before we do that as well, let's listen to the non-emergency call that Mr. Zimmerman made. What I'd like to do is play it from beginning to end without anything else. And then I will like to point to certain parts of it I would ask you to listen to when it comes into evidence and make note of. So it's only, 4 minutes long. Mr. Pinella, if you would help me with that.
Center Police Department line stand reports the shots.
Hey, we've had some break-ins in my neighborhood, and there's a real suspicious guy. It's Retreat View Circle. The best address I can give you is 111 Retreat View Circle. This guy looks like he's up to no good, or he's on drugs or something. It's raining, and he's just walking around looking about.
Okay, and this guy, is he white, black, or Hispanic?
He looks black.
Did you see what he was wearing?
Yeah, a dark hoodie, like a gray hoodie, and either jeans or sweatpants and white tennis shoes. He's here now. He was just staring.
Oh, he's just walking around the
Looking
area.
at all the houses.
Okay.
And now he's just staring at me.
Okay, and so it's 1111 retrieve you or 111?
That's the clubhouse.
That's the clubhouse. Do you know what he's near the clubhouse right now?
Yeah, now he's coming towards me.
Okay.
He's got his hand in his waistband. And he's a black male.
Okay. How old would you say he
He's
looks?
got a button on his shirt. Late teens.
Late teens? Okay.
Something's wrong with him. Yeah. He's coming to check me out. He's got something in his hands. I don't know what his deal is.
Okay, just let me know if he does
Get an
anything,
officer
okay?
over here.
Yeah, we got him on the way. Just let me know if this guy does anything else.
Okay. These assholes, they always get away. Yeah. When you come to the clubhouse, you come straight in and make a left. Actually, you would go past the clubhouse.
Okay, it says on the left-hand side from the clubhouse?
No, you go in straight through the entrance, and then you make a left. Yeah, you go straight in. Don't turn and make a left. Shit, he's running.
He's running? Which way is he running?
Down towards the other entrance of the neighborhood.
Okay, which entrance is that he's heading towards?
The back entrance.
Are you following him?
Yeah.
Okay, we don't need you to do that.
Okay.
All right, sir, what is your name?
George. He ran.
All right, George, what's your last name?
Zimmerman.
And George, what's the phone number you're calling from?
407-435-2400.
All right, George, we do have him on the way. Do you want to meet with the officer when they get out there?
Yeah.
All right, where are you going to meet with them at?
If they come in through the gate, tell them to go straight past the clubhouse and straight past the clubhouse and make a left. And then they go past the mailboxes. They'll see my truck.
Okay, what address are you parked in front of?
I don't know. It's a cut through, so I don't know the address.
Okay, do you live in the area?
Yeah.
Well, what's your apartment number?
It's a home. It's 1950. Oh, crap. I don't want to give it out loud. I don't know where this kid is.
Okay, do you want to just meet with them right near the mailboxes then?
Yeah, that's fine.
All right, George, I'll let them know to meet you with you out there. Okay?
Actually, could you have him call me and I'll tell him where I'm at?
Okay, yeah, that's no problem.
You need my number? You got it.
Yeah, I got it. It's 407-435-2400.
Yeah, you got it.
Okay, no problem. I'll let them know to call you when they're in the area.
Thanks.
You're welcome.
One thing that I failed to mention, and I'll just, before we go back through the actual timeline, is I showed you where George Zimmerman lived. Here we are. Clubhouse, pool, T. And that Trayvon Martin was staying in the neighborhood with his father's girlfriend. Her name's Brandy Green. She has a 12-year-old son, Chad Johnson, I believe, that Trayvon Martin was sort of hanging out with. There were no adults home in that night. It was only 6 o'clock, 7 o'clock, and it was the All-Star game that before that had gotten underway. So, but that's down here.
in this area. Just to kind of, okay. If we could go back then to the beginning of the call. And let's take a look at the times. I'm sorry, let's, at the very top. The very top of the display. Can you go back to the beginning? You know, I think if you take the button on the bottom and just pull it all the way to the left, you'll get to the front. Yeah, there we go. Now, let's take a look at the times. Stay on that one. Okay, stay. There might be a second or two, depending on where the record came from, but within a second or two of each end, this is George Zimmerman's call to the police. The non-emergency call timeline was connected after he had seen Trayvon Martin at 7:09:34. That's the call with Sean Nofke. And that call disconnected at 7:13:40. All right, next. I'm looking for the beginning of the call. Yes, right there. This is the sort of the parallel calls connected here. You see that while there had been lots of other calls and a ton of text and all sorts of things that day, the second to last call between Rachel Gentile and Trayvon Martin started at 6:54:16. So that was well before George Zimmerman called the police. And then it ended at 7:11:47. That's what I said a moment ago. We'll tie it up at the end. About 20 seconds later, they reconnected. I submit that 20 seconds won't turn out to matter very much because you'll soon learn that George Zimmerman was on the phone during that entire time with the police. Okay, so let's walk through it just a little bit more. Next. So George Zimmerman says to Sean Nofke, he's just staring at me. Mr. Nofke asks, is near the clubhouse right now? And Mr. Zimmerman says, yeah, now he's coming towards me. What that's all about is this. George Zimmerman saw Trayvon Martin over in this area as he was coming around here to go out to Target. He pulled over to make the call in the vicinity of the clubhouse. So when this part of the conversation is taking place, Mr. Zimmerman is sitting here on the phone with the police. So they're talking about the clubhouse. Next. The dispatcher, after hearing what George Zimmerman said, okay, just let me know if he does anything else. And George Zimmerman says, get an officer over here. Please get an officer. The little discussion was, do you want somebody? Yes. Please get an officer over here. Directly asking the dispatcher to please send a police officer to the neighborhood. And then it's repeated by the dispatcher, just let me know if this guy does anything else. 7 or 8 seconds later, George Zimmerman laments, if you will. He's been involved in the community for a while. He's made other calls. In fact, his role as the liaison with Neighborhood Watch was that there's one point person with Wendy Dorval. So instead of all of the residents calling her with any issues, Mr. Zimmerman coordinated that. So residents would ask him to phone in something or to report something. So he was familiar with what was going on in the community, not just from his own experience, but from having
been involved as the coordinator liaison. In fact, there was an attempted break-in just a couple of weeks before, right around this area. Right around this area. So you can hear him say it. We'll play it one more time before we're done with this. These assholes always get away. Next. George Zimmerman's still in the car. By that time, though, he has moved. Was he following Trayvon Martin? Yes, he was following Trayvon Martin. Trayvon Martin continued to walk this way or jog this way. In any event, he kept moving this way. And George Zimmerman did too. He was following him at a distance and reporting what he was seeing to the police and describing what was happening. So when the dispatcher Nofke said, "Let me know if he does anything else," George Zimmerman was doing that. He was following him in the car and got up to about here. That's where the car was. And says, "Shit, he's running." The dispatcher says, "Which way is he running?" He's running. Which way is he running? Suggesting that he would like Mr. Zimmerman, submit, to tell him which way he's running. But it's a cut through. You can't drive in that direction. You can only see which way he's running if you get out of the vehicle to see where he went. So, George Zimmerman at 7:11:43, you can hear this, we'll play it again so you can listen for it, unbuckles his seatbelt and opens the car door. You can hear the chime, and you'll hear the door shut at 7:11:48. Okay. I didn't write it down. Maybe one of you did. I seem to remember that the call ended between Trayvon Martin and Rachel Gentile right about that time, 7:11:47, something like that. Yeah, 7:11:47. All right, so at this point, when George Zimmerman opens the car door, gets out of the car, that call had just ended. They had been losing calls on and off all day. That wasn't a surprise to anybody. One call the other call back. There's no reason ascribed to this by Ms. Gentile other than they'd been having trouble with the system. So the call ends. And then at 11:48, right there, that's when Mr. Zimmerman gets out of the truck and the dispatcher says, "Which entrance is that?" He's headed towards the back entrance. You will start to hear some noise, I think the evidence will show you, in the background that suggests that Mr. Zimmerman is out of the vehicle. Whether it's breath noises, wind noises, how fast Mr. Zimmerman was moving, no suggestion that he was actually running, but you can hear more noise going on, and it's evident from the recording that he's out of the vehicle. So, he says, almost under his breath, "These fucking punks." At that point, Trayvon Martin had been staring at him. He'd approached him. He had his hand in his waistband. And then he took off. Right then, Sean Nofke, the dispatcher, figures out more of what's going on. He realizes, probably due to some of the additional noise, that it seems like Mr. Zimmerman is out of the vehicle and says, "Are you following him?" And George Zimmerman doesn't say no. He says, "Yeah, I am following him." And what he had done by then is he had gotten out of the vehicle and had gone in this direction. So he's coming right down here when you're hearing the noise and when you're hearing the discussion about which way is he running. And then he's up around here. To me, it's not clear from the evidence. Pay attention to it if you would. There's a woman up here, her name is Jane Serdyka, that saw parts of this at different points in time. She said she thought she heard a voice, or maybe voices, a minute or two, 3, she's not clear on the time, before the exchange that turned into the event. It might have been George Zimmerman talking on the phone with the dispatcher. There's no way to know that for sure, but it would be somewhat consistent, I would think. We'll need to hear what she says exactly to know if that's possible. If it isn't, then it could have been someone else, perhaps. This was the dog path. This is where people would take their dogs and walk them, and the disposal station is here. So, in any event, George Zimmerman is coming along here talking with the dispatcher, and Sean Nofke says, "Are you following him?" George Zimmerman says, "Yes." And Sean Nofke says, "We don't need you to do that." George Zimmerman says, "Okay." Suggesting, I suppose, you don't need to do anything more to tell us which way he went, where he went, or even if he's doing anything else. So George stopped. George Zimmerman stopped. This is the pickup on the call between witness A. That's Rachel Gentile. As you may know, there's been some anonymity issues throughout the case. There aren't now, except for the jury, of course. So if you see something in the trial that's marked with a witness number, we'll try to remember to tell you who they are so you can keep all that straight. It would be unreasonable to ask you to keep all the witness numbers straight. So that's Rachel Gentile. She's 19 now. She was 18 at the time in February of 2012. And she came into this case mid to late March, about 3 weeks after the event. And a little later I'll explain to you how that happened, what the circumstances were, and ask you to consider certain things in evaluating her testimony. So at this point, it's routine for Sean Nofke. He asks George Zimmerman, "What's your name?" "George." And George repeats, "He ran." This is a statement made by the dispatcher to Mr. Zimmerman, keeping in mind the police are on their way. Mr. Zimmerman asked a few moments ago to please send an officer, and Mr. Nofke assured that they had. And Mr. Nofke says to Mr. Zimmerman, for sort of orientation purposes, "What address are you parked in front of?" Then there was a little confusion because he was parked over here, but there aren't any street signs right here. So unless you actually have memorized the name of the street, you can know where you are. I think we've all done that. We know exactly where we are, but we don't happen to be able to know the name of the street. There's a question whether this is, in fact, I don't know if it's Twin Trees or Twin Lakes. It's one or the other. But this is Retreat View Circle. And it goes all the way around. In fact, George Zimmerman lives on Retreat View Circle down here. So there was some confusion about what address
So Mr. Nofke got to the heart of it and said, "Do you live in the area?" Mr. Zimmerman, "Yeah." "Okay, what's your apartment number?" Orienting. So, next. It's a home, meaning a townhome. These are all townhomes, similar design. And then Mr. Zimmerman realizes he just gave, or was about to give, his address out loud. And stops and catches himself because he does not know where Trayvon Martin is. He ran, he lost him, he can't provide any information to the police, which way was he running, or where he is, and he says, "Oh crap, I don't want to give that out, I don't know where this kid is." Well, you'll see the evidence proves at least one thing. Trayvon Martin hadn't gone home. We know that. We also know it was almost pitch black out. Mr. Guy pointed that out. This was a picture taken by one of the investigators for the medical examiners group when they got there. The police had already cordoned off the area, put the line, the tape up that you see. Taking a picture with a flash. Right here. That's with the flash. I won't. You can see the building on the corner. You can see some stuff in here. The only point now is it was really, really dark. Now, this was later, admittedly, and we were still talking only 7 in the afternoon, evening in February, but all of the witnesses agreed it was dark. It had been raining all day. It was just plain dark. The sun goes down, 4:30, something like that in the winter. So George Zimmerman says, "I don't know where this kid is. I don't want to give my address out loud." Next. Some more conversation. Well, where do you want to meet the officers? You want to meet them at the mailboxes. Mr. Zimmerman says, "Okay." And then he says, "Well, you have my number, right? This is the era of cell phones. We are immediately in contact. So instead of meeting at a specific location, keeping in mind the mailboxes are over here. Mr. Zimmerman's truck is here. Mr. Zimmerman says, just have him call me. You got my number, and I'll tell you where I am." If you don't mind, let's just play it through one more time. It's only 4 minutes, and we'll be done with this part.
Sanford Police Department, lines being recorded. Sean?
Hey, we've had some break-ins in my neighborhood, and there's a real suspicious guy. It's Retrieveview Circle. The best address I can give you is 111 Retrieveview Circle. This guy looks like he's up to no good, or he's on drugs or something. It's raining, and he's just walking around looking about.
Okay, and this guy, is he white, black, or Hispanic?
He looks black.
Did you see what he was wearing?
Yeah, a dark hoodie, like a gray hoodie, and either jeans or sweatpants and white tennis shoes. He's here now. He was just staring.
Oh, he's just walking around the area?
At all the houses.
Okay.
And now he's just staring at me.
Okay, he said it's 1111 Retrieveview or 111?
That's the clubhouse.
That's the clubhouse. Do you know what he's near the clubhouse right now?
Yeah, now he's coming towards me.
Okay.
He's got his hand in his waistband. Yeah, he's a black male.
Okay. How old would you say he
He's
looks?
got a button on his shirt. Late teens.
Late teens, okay.
Mm-hmm. Something's wrong with him. Yeah. He's coming to check me out. He's got something in his hands. I don't know what his deal is.
Okay, just let me know if he does
Get an
anything,
officer
okay?
over here.
Yeah, we got him on the way. Just let me know if this guy does anything else.
Okay. These assholes, they always get away. Yeah. When you come to the clubhouse, you come straight in and make a left. Actually, you would go past the clubhouse.
Okay, it says on the left-hand side from the clubhouse?
No, you go in straight through the entrance, and then you make a left. Yeah, you go straight in. Don't turn and make a left. Shit, he's running.
He's running? Which way is he running?
Down towards the other entrance of the neighborhood.
Okay, which entrance is that he's heading towards?
The back entrance.
Are you following him?
Yeah.
Okay, we don't need you to do that.
Okay.
All right, sir, what is your name?
George. He ran.
All right, George, what's your last name?
Zimmerman.
And George, what's the phone number you're calling from?
407-435-2400.
All right, George, we do have him on the way. Do you want to meet with the officer when they get out there?
Yeah.
All right, where are you going to meet with them at?
If they come in through the gate, tell them to go straight past the clubhouse and straight past the clubhouse and make a left. And then they go past the mailboxes. You'll see my truck.
Okay, what address are you parked in front of?
I don't know. It's a cut through, so I don't know the address.
Okay, do you live in the area?
Yeah.
What's your apartment number?
It's a home. It's 1950. Oh, crap. I don't want to give it out loud. I don't know where this kid is.
Okay, do you want to just meet with them right near the mailboxes then?
Yeah, that's fine.
All right, George, I'll let him know to meet you with you out there, okay?
Actually, could you have him call me and I'll tell him where I'm at?
Okay, yeah, that's no problem.
You need my number? You got it.
Yeah, I got it. It's 407-435-2400.
Yeah, you got it.
Okay, no problem. I'll let them know to call you when they're in the area.
Thanks.
You're welcome.
Okay, 7:13:40, the call ends. Keeping in mind that by this time, Trayvon Martin was back on the phone with Rachel Gentile and stays on the phone for the next couple of minutes. So, you'll hear more about Ms. Gentile and what she heard, but I think more importantly, perhaps, what she didn't hear if George Zimmerman was actively pursuing, chasing with the intent to confront and murder Trayvon Martin. Second-degree murder requires an act reckless, indifferent to human life, a depraved mind act, ill will, hatred, spite. What Rachel Gentile will tell you in her conversation with Trayvon Martin, at the moment that this actually became physical, was that Trayvon Martin, I'll use my words, that Trayvon Martin decided to confront George Zimmerman. That instead of going home, he had plenty of time. He had, this is what, 60, 70 yards? Plenty of time. Could have gone back and forth 4 or 5 times if he wanted to. But choosing not to do that, he either left and went back or just hid in the darkness to see about this guy that he thought was following him. And turned to George Zimmerman out of the darkness and said, "Why are you following me?" Or something to that effect. And we know that was
pretty close in time to the end of this call. Pretty close. We don't know exactly when. But if you accept what Rachel Gentile says she heard, whether it's accurate or not, whether it was exactly the words, "Why you following me for?" or something to that effect, that's basically the last thing she heard. There'll be some other things we'll talk about, but that was when Trayvon Martin made the decision to confront George Zimmerman and say, "What are you following me for?" So how does that fit together? I'll show you. Thank you. The T, keep that in mind, the T up here. This is a slide, I guess you'd call it, or a diagram, just for orientation. This is the T. There's the dog thing. As I said before, we were using witness numbers rather than names. And what this shows you is a slide that positions the evidence that was marked, identified, and collected by law enforcement after the shooting. Let's talk about a little of that first. No, let's do this. This is where Jenna Lauer and Jeremy Weinberg lived. Jenna Lauer is the one who made the call when she heard the commotion out here in the neighborhood, in the vicinity of the T. She describes what she heard as some loud voices. She called it a sort of three-part exchange, like an accusatory or confrontation voice, a response, and another one, kind of a three-part exchange. Heard that off to their left. They were watching TV out here. This is screened. And behind it is the sliding glass door that was open. However, they couldn't see anything because they had these little bamboo slatted blinds that were down. So they couldn't see it, but they knew something was happening. Enough that it got their attention, they decided to call the police. With this three-part exchange, they started to hear what they thought maybe was scuffling feet on grass, and then they started hearing someone moaning or crying for help. They dialed the phone. I'm trying to remember. I think they tried a phone and it wasn't on, or they couldn't get it to work, so they tried the other one. But within just a few seconds, they got through. Keeping in mind that I think the call was connected at 7:16:11, something like 30 seconds after the call with Trayvon Martin and Rachel Gentile ended. So we're only talking about 30 seconds, including the time it takes to dial the phone, get the phone, dial the phone, figure out, hey, there's something going on here, make the call, connect the call, and you'll hear the operator here in a second. You've all heard those anyway, those operators. So, hearing the exchange, the voices, hearing what they thought was something going on, they called the police. They called emergency services. And here's what they heard. Here's the call. This is the call with the screams. This is the call with the shot, to keep in mind. The shot occurs about 40, maybe 45 seconds into this recording. There is a sound, though, that precedes the shot by a few seconds that on first listening sounds like it could be a shot. It's not. There's no mistake, no dispute in this case that George Zimmerman fired one and only one shot. That is proven by forensic evidence. I'll digress for just a moment. The reason we know that, not like he fired once and missed, not like he shot 2 times, as you might think if you hear this. Mr. Guy gave you the answer. Any of you that are familiar with firearms know that you can put an additional round in the gun after the magazine itself is full, simply by putting one into the chamber and then putting another one into the magazine. So if the magazine holds 7, you can actually put 8 rounds in the gun. It's clear that's what happened in this case because the police found 1 shell casing and the magazine still was filled to capacity. So there was only 1 shot, no matter how you look at it. We'll talk more about the gun here in a little bit, too. Let's get on with the call. Mr. Pinello, would you help me with that, please?
911, do you need police, fire, medical?
Maybe both. I'm not sure. There's just someone screaming outside.
Okay, what's the address that they're near? Is this in the Twin Lake Toms in Sanford?
Yes.
Okay, and is it a male or female?
It sounds like a male.
And you don't know why?
I don't know why. I think they're yelling help, but I don't know. Just send someone quick. Say stop.
Okay. Does he look hurt to you?
I can't see him. I don't want to go out there. I don't know what's going on. So they're sending him.
So you think he's yelling help?
Yes.
All right, what is your number?
Just there's gunshots.
You just heard gunshots?
Yes.
How many?
There's one. Get down. No, come here.
Is he no longer yelling?
I don't know. Get in here now. Get up here.
All right, is he right outside?
Yeah, pretty much out the back, yeah.
Is he in front of it or behind that address?
He's behind my house.
Okay.
Just stay away from the windows.
I don't hear him yelling anymore. Do you hear anything?
I'm going to stop it there, only because obviously the screaming is over, the shot has been fired, and this is a discussion. You'll have the opportunity to hear the whole thing as many times as you want, and I hope that you do. I hope that you listen to it 1, 5, 10, 50 times if you need to. The same thing with the non-emergency call. You'll have it in evidence. You can listen to it as many times as you want. But what we know, obviously, everyone agrees to this. All of the witnesses, whether they agree to anything else, they all agree those are the screams of someone in a life-threatening situation. Someone screaming repeatedly over and over and over for help, needing desperately for someone to come to their assistance. It wasn't, that's the only recording of any that shows what it shows. There were some other 911 calls. That's the only recording that I can think of that actually has these events on it. It's certainly the best quality, and it's not that great. Why? Because it was recorded on a cell phone in Jenna Lauer's hand inside her unit 20 or 30 or 40 feet away from where the sounds were being made. Cell phone technology isn't designed to capture the full range of sounds. It's designed for people to be able to hear what the other person is saying and to have lots of those conversations going on at the same time. So it has some acoustic challenges, if you will. It may not contain all of the screams, for example. It certainly wouldn't contain anything that's not that loud. But it is what it is. So what happened then, this is a quiet Sunday night, it's raining, quite a few people are home. Other people also hear something going on. This woman up here, her name is Jane Serdyka, heard the voices. She saw some of the scuffle. And she believes that she saw Trayvon Martin and George Zimmerman at the time of the shot. But she's wrong about that. You'll find, I think, in this case that there are well-meaning and honest people that, based upon limited information or preconceived notions or biases, mean well but just somehow get it wrong. I'll tell you why for just a second, then we'll go on. The reason she got it wrong is that she saw what she thinks was George Zimmerman on top of Trayvon Martin at the time the shot was fired. And that Trayvon Martin was on his stomach, that he was face down. That couldn't happen. That could not have happened in this case. We're going to talk about some forensic evidence here in a bit, but we know that couldn't happen. So she could not have seen the moment where Trayvon Martin is shot. Why? It's really pretty simple, because Trayvon Martin was shot in the chest, not in the back. So if Trayvon Martin was lying face down when she saw George Zimmerman on top of him, then she didn't see it. She saw it later. Only a few seconds later, as other people in the neighborhood will describe something similar, but it was after. We'll talk a little bit more about that. I don't know if you're following what I mean. I'm not trying to jump ahead too much, but people heard some screaming around. They've described it different ways. Some heard only a couple. Some heard more than that. Some thinks they saw or heard a fight of some sort with in various positions, up or down, flailing, or what have you. But except for Jane Serdyka, who I just explained how, and you'll hear her testimony, got it wrong when piecing all of this together in her own mind. She didn't see a muzzle blast. She saw Trayvon Martin face down. She saw George Zimmerman on top. And there was that moment. There's no question that there was that moment when Trayvon Martin was shot. He fell forward, face down. George Zimmerman was underneath him, and within a few seconds, 2, 3, 4 seconds, basically switched positions. And when you hear the shot and you figure out what that's all about, and you go outside to look, if it takes you 2, 3, or 4 seconds, that's the image that you see. That's what you see, George Zimmerman on top of Trayvon Martin with his hands pressed down on him. 2 or 3 people saw that. And they did see it. They're right. It's just that it was after the shot. There is someone, though, who actually saw Trayvon Martin and George Zimmerman together before the shot, just moments before the shot. You could probably piece it together, 10, 15 seconds maybe before the shot. The reason you can piece it together is he also called 911. So you can connect up some of the dots. You can figure out when the shot took place. You can figure out when the calls were made, and then roughly figure out when in this sequence he saw what he saw. I'll leave that to you, but I'm going to suggest it's probably 15 seconds, 10, 15 seconds. But here's what he saw, and here's who he is. His name is John Good, and he lives right here. He lives next door to Jenna Lauer and Jeremy Weinberg, right next door. He heard the noise. He heard the screaming, the cries for help, and he went to investigate. He doesn't have the screened-in porch. He has the sliding glass door. So he goes out the sliding glass door, and he's right here on the patio, his patio. From here to here, I don't know, 15 feet, 20 feet maybe, right in front of him. Me to you. And here's what he sees. Now, he doesn't know who it is at this point. He doesn't recognize anybody. He didn't see faces. But he could clearly see colors, and there was no mistake the color of the clothing of the people that he was seeing. He was very clear. There was one of the participants, if you will, one of the people involved, was wearing a dark shirt. Black almost, especially because it was so wet. That was Trayvon Martin. He had a charcoal-colored, hooded sweatshirt. On the other hand, George Zimmerman had a red-colored jacket. Very different, no mistaking the two. At first, John Good wasn't quite sure what he was hearing or even what he was seeing. He thought it might have been a dog attack or something. He wasn't even quite sure it was two people. And he got outside, and then he saw it was two people. And he saw them moving a bit up towards the sidewalk. He saw a person that he described as the one with the black top mounted on the person with the red shirt. Mounted is a term used in mixed martial arts, fighting. Some of you know more about that than I do, no doubt. Mounted is when you straddle the person around their hips. They are pinned underneath you. They are essentially helpless. He saw Trayvon Martin with the dark-colored shirt mounted on George Zimmerman. He saw George Zimmerman in the red-colored shirt on his back. He described what he saw in the same terms of this mixed martial arts vernacular. He called it a ground and pound. A ground and pound. That's the words that he used. A ground and pound is when you're mounted on somebody, they are helpless, and you are basically beating them senseless. He may have seen some of this, he may have seen some of that. It's dark, and he didn't get a long look, but he saw enough to know this was serious. What did he do? He yelled at them, "Stop it," or "Cut it out," or something like that. I don't think you can hear that on the recording. I think that gives you an example of what you can hear on the recording and what you can't. John Good will tell you he yelled something at them, probably "Stop it" or "Cut it out." And you know what happened at that point? Nothing. Except two things. George Zimmerman cried out for help, looked at him, looked at John Good, and said, "Help me, help me." And Trayvon Martin kept on hitting. So John Good did this. He went back inside to call 911. The right thing to do, perhaps, the smart thing to do, no doubt. But George Zimmerman was crying out for help, and no one helped. And it continued. It continued until you hear the shot. You can hear the cries for help up until the moment of the shot. And then there's no more cries for help. Why would there be? So, there was enough commotion, enough people heard these yells, that they started coming out to check it out. But after the shot, right after the shot, though, from their doorway, a couple of people looked right outside and saw this. They saw Trayvon Martin face down and George Zimmerman on top of him, kind of holding his back or his arms or something like that. One of them maybe even yelled at him, and he kind of turned at one point. One of them saw Trayvon Martin's leg move, they think. Nobody heard any more sounds, though. My guess is that the silence was deafening at that point. George Zimmerman struggled to his feet. He was out of breath. He was injured. According to Jonathan Manalo, that's the guy on the corner. Right here. Oh, this is kind of weird. It's right here. This is a shadow or something because of the angle. Jonathan Manalo lives on the corner. This is the T. This is where John Good lives. This is where Trayvon Martin's body was, right in front of John Good's house. Jonathan Manalo comes out. He hears the commotion. His wife hears the commotion, actually. He says, well, just leave him alone. Don't get involved. Then they hear the shot, and he comes running, if you will. He comes out with a flashlight. He is here within seconds. And what does he see? What he sees is George Zimmerman as I'm staggering. George Zimmerman says to him, am I bleeding? Jonathan Manalo says, yes. Yes, you are. In fact, for no reason other than what he was seeing, he took a picture of George Zimmerman's head with his cell phone. This is within seconds of the shot. This is the back of George Zimmerman's head. Here's the red orangish jacket. I think that's probably the sidewalk. Jonathan Manalo had a flashlight and a cell phone. He took this picture. He took a couple of other pictures, too, that will show you in evidence that actually show Trayvon Martin's body there in the position that it was immediately after he was shot. I won't show you those now. You'll see them in evidence. You'll see exactly where they are. You'll see the position. One witness described it as if he were riding a bike. I suggest that it's because he was straddling George Zimmerman when George Zimmerman shot him. And when he fell forward and his legs were still in that same position. As George Zimmerman scrambled up to get out from under him, he stayed right like that. So what happens then, Jonathan Manalo is there. He takes this picture and he says, what happened? George Zimmerman says, he was beating me up and I shot him. George Zimmerman wanted Jonathan Manalo to call his wife, George's wife Shelley, which he did. Jonathan Manalo, as Mr. Guy pointed out, said something that sounds a bit odd, so let's talk about it a minute. He described George Zimmerman, first of all, as breathing hard, having just gotten his butt beat, staggering, and then, though, somehow calm, as if nothing had happened. I submit that what the evidence will show is that George Zimmerman had just experienced the most traumatic event of his life. He probably didn't know what state he was in, literally what state he was in, much less his emotional state at that moment being particularly significant to suggest that if he acted like he was calm, he didn't care, as if he was acting out of ill will, spite, evil intent, disregard for human life. That's what murder is in this case. That's what the state has to prove, that that's what George Zimmerman did and acted that way. And on that, Jonathan Manalo saying, wow, it struck me he was calm. I submit it may be flat, affect, something. But a guy who's staggering and bleeding, who just got his butt beat, who it's obvious had been crying for help for 40 seconds before he took that action to save his own life, is not going to be calm. We know he was injured more than just this. Jonathan Manalo saw injuries on his face. Tim Smith is the police officer with Sanford who showed up first. Keep in mind that George Zimmerman asked that a police officer be sent to the scene, and Sean Nofke said, okay, they're on their way. And they were. They got there very soon after the shot, moments after Jonathan Manalo was there with George Zimmerman. And Officer Smith said, who shot him? George said, I did. George Zimmerman. Following police protocol, Officer Smith handcuffed George Zimmerman. They call that for officer safety. Makes a lot of sense to me. There's a guy with a gun, someone dead. You'd want to take the guy who said, I shot him, and cuff him, which he did. No resistance, no complaining, no explanation by George necessary. He just cuffed him, took his gun. The gun was in a holster on the right side. I had a Somebody keeps moving my stuff. Sorry. I'll describe it for you. It was a little inside the waistband holster. Thanks. So here's the holster. No big deal. It fits inside the waistband like this. Here's a picture of the holster itself that was in evidence. Here's a picture of the gun. As Mr. Guy said, it's a Kel-Tec 9mm semi-automatic, double action only handgun. That's important in the sense that it doesn't have an external hammer. You can't cock it and then pull the trigger. Double action, you pull the trigger, the hammer goes back and then forward. It has an extra strong trigger pull as a result of that. It's designed to be carried loaded, and in that position. It doesn't have an external safety, if you will. The way George Zimmerman was carrying the gun was the way it was supposed to be carried. We'll talk more about the gun in a minute. But, in fact, the training that George Zimmerman got from his friend, the Federal Air Marshal, was exactly what George Zimmerman did. It was the kind of gun that was recommended to George Zimmerman, the double action only, round in the chamber. It's safe as long as you're responsible. We'll talk about gun responsibility too before we're all done. However, Tim Smith, the Sanford Police Department, takes George into custody. He gets the gun, the holster. This is the magazine that had the bullets in it. And takes him over to the patrol car while they sort things out. Smith is over off of, well, you know it by now, off of Retreat View Circle, on that big street that goes around. He's parked over there, and George Zimmerman is placed in the back of the patrol car, handcuffed. Additional officers arrive. The crime scene is taped off. Residents start coming out, trying to figure out what's going on. That's when Eloise Dilligard, the neighbor of Mr. Zimmerman's, drives up there and sees his truck, knows there's something going on, and says to herself, well, I'll just ask George. So in the meantime, George Zimmerman's in the back of the patrol car, and Ms. Lauer is asked to identify him. Can you identify anybody? And she doesn't want to go see this person that just shot someone. So she says, take a picture. That's to Mike Wagner. Mike Wagner's on the scene. He's with the Sanford Police Department. It's too early. Crime scene isn't there yet. They don't have all their equipment. They're just starting to get a handle on this. So Officer Mike Wagner takes a cell phone and takes a picture of Trayvon Martin's face. By then, other officers had turned Mr. Martin's body over. CPR was started. Tragically, there was nothing that could be done. Indeed, the shot did penetrate the heart, the right ventricle, massive bleeding, death, loss of consciousness very soon, death not too long thereafter. So Wagner took a picture of Trayvon Martin's face, and then he went over and took a picture of George Zimmerman's face, not to document his injuries, but so he could show the picture to residents, any other witnesses that might be there, to say, do you know who this guy is? Nobody knew who Trayvon Martin was. They wouldn't have had this picture at this point. They would have had no identification. There was no identification on Mr. Martin. He had a cell phone there, which they couldn't get to work. And there was nobody there that knew who he was, keeping in mind that Mr. Martin and Ms. Green were not home that night. Ms. Green's son, Chad, was, but he was headphones, video games. He didn't even know anything had happened. They were way down there, on the map. Way down. He lived down here. Didn't even know this was going on. So no one was able to identify who Trayvon Martin was, but not for lack of trying by the police. So this is Trayvon Martin, by the way, at the 7-Eleven. This is where he went to get the candy, the Skittles, for his the friend Chad, and the Arizona brand fruit drink. It was a 23-ounce can full. That's important to remember, and I'll talk about that in just a few minutes, why that's important. So this is the person that George Zimmerman saw when he called the police to say, there's someone in the neighborhood, I don't know who he is. Of course, Trayvon Martin is wearing the hoodie in the store. This guy right here, his name is Andrew Gaw. He doesn't remember this event, but he's 5'10". He told us that under oath. He's 5'10". Trayvon Martin is 5'11", as measured by the medical examiner. He had shoes on, and he had a hooded sweatshirt on, which makes him well over 6 feet tall, as you can see. We know that he weighed 158 pounds. He wasn't skinny. 158 pounds at 5'11" is right in the middle. But so Mike Wagner takes this picture of George Zimmerman to show Jenna Lauer and anybody else to tell them, who is this guy? Jenna Lauer says, looked at it, I don't know. Didn't know him immediately. And then Eloise Dilligard, who by then was there, said, that's George. That's George. Ms. Lauer, who knew George from the neighborhood, didn't recognize him because of all the injuries. Ms. Dilligard, who lived right near him, did. This is the picture taken from Mike Wagner's cell phone that was shown to Jenna Lauer and provided to us in evidence. This is the second picture taken of George Zimmerman that night. That's the first, by Jonathan Manalo. And here's the second. This is taken while George Zimmerman's in the back of the patrol car while the police sort this out. Again, you'll have the opportunity in evidence to examine it carefully and closely. But let me point out a couple of things. The abrasion to the side of the nose, marks and abrasions on the forehead, the swollen and seemingly deviated nose at that point, suggesting that George Zimmerman took quite a wallop squarely in the face. And of course, the blood. It's still glistening. It's still glistening. George Zimmerman cooperated fully. He went to the police department that night. He answered all their questions as many times as they wanted, as many days as they wanted. He had just taken tremendous blows to his face, tremendous blows to his head. But he didn't ask for a lawyer. This is such an incredible case that the man who shot and killed Trayvon Martin is fully cooperative, doesn't ask for a lawyer day after day, takes any test is offered, answers any questions, goes back as many times as they ask, never asks for a lawyer. Yet it seems as though about half the witnesses in the case have lawyered up. Remarkable. Never seen anything like that. So George Zimmerman stays at the Sanford Police Department that night in custody for several hours. During that time, he's interviewed. I submit to you it was unfortunate. Well, I'll back up. The paramedics, of course, came to the scene, and as soon as they attended to Trayvon Martin, they then attended to George Zimmerman. They cleaned him up, if you will. They needed to see what injuries he had. He was covered in blood. So they used peroxide and what they do to clean it up. They saw the lacerations on the back of his head. They saw the nose and the blood. And they talked to Mr. Zimmerman. He seemed pretty well oriented. Mike Brandy is the paramedic that was there, who suggested to law enforcement, after all, Mr. Zimmerman's in custody. He doesn't get to make decisions at this point. Mike Brandy, the paramedic who examined Mr. Zimmerman, said, I think he should go to the hospital. You know, he's had head trauma. He's obviously injured. And the police said, well, we'll deal with it. You don't need to transport him. We'll take care of it. It didn't happen. I'm not complaining about that particularly, because pretty soon thereafter, Mr. Zimmerman was taken to the police department. There's video that shows him in the Sally port, they call it. That's where you come in a secure area, get out, go upstairs. There's video everywhere. You can see him. You can't see much on his head at that point, although you can on close inspection, because he'd been cleaned up by the paramedics. He goes upstairs. In the meantime, Diana Smith, who is the crime scene person, is at the crime scene. She's doing all this stuff. She's marking all the evidence, taking it into account. Pretty soon the medical examiner's investigator shows up. So she's busy. So Mr. Zimmerman's at the Sanford Police Department for several hours. And during that time, he washes up, if you will. He gets rid of the blood on his face that the paramedics had missed, and he just is there. His clothes are taken for processing. His wife is allowed to bring another change of clothes for him. And he sits and he talks. He'll answer any questions. Doris Singleton is the investigator that was with George Zimmerman at the Sanford Police Department that night. The lead detective is investigator Chris Serino. He was at the scene. He was interviewing residents. He was watching what was happening with the evidence collection. They were doing a canvass. They did several of those, actually, to see who had seen what, if anything, and taking witness statements. One of the witness statements that was taken was John Good. Remember him? He was the eyewitness. And he drew a sketch of what he had seen right out his door. So this is what the police knew already that night, while Mr. Zimmerman is up in the Sanford Police Department. Mr. Good's house, there's like 2 sketches here built into one. In fact, he numbered them. So he sees the sidewalk, red top, bottom, black top, on top. Trayvon Martin had the black shirt. George Zimmerman had the red one. Again, now they're up towards the sidewalk. Again, he knows it's serious now. Red shirt, bottom, black shirt, top. So George Zimmerman is at the Sanford Police Department in custody, being interviewed, waiting for something to happen. And it's midnight or later, several hours later. Diana Smith is doing the crime scene work. That's represented here. We'll talk about that in a minute. I believe her name is Tara Malfers, is the investigator with the medical examiner. The medical examiner in this case was from Volusia County. His name is Shipping Bao, B-A-O. He's the pathologist who performed the autopsy. When Mr. Martin's body was transported, they did not yet know who he was. So the body was sent to the medical examiner's office. It was in the blue body bag that we've all seen. It was marked with the identifier of the case number, and the autopsy was done the next day. Tara Malfers is on the scene, and she takes pictures too. In addition to Diana Smith from Sanford, Ms. Malfers takes, she may have a different name, a different married name now, but we'll know who she is. Tara Malfers takes pictures and is involved in the livery aspect of it. In the meantime, George Zimmerman's at the Sanford Police Department. Around midnight or so, Diana Smith is done at the scene. Evidence has been marked and collected. It will be then submitted to the lab for processing of all sorts of processing. That's the forensic evidence part of this. And she goes to the Sanford Police Department. She takes pictures of the gun, showed you those. and she takes lots of pictures, I think it was 30 or so, of George Zimmerman. By then, he'd been all cleaned up and several hours had passed, so it's not nearly, of course, as dramatic as these. But you can clearly see the cuts in the back of the head. You can see more of the sort of abrasion, what do they call it? Punctate abrasions, for those of you with some medical background, on his scalp. But what you can really see in these pictures that you'll have in evidence are the lumps, the big knots on each side of his head, consistent with having his head slammed into concrete. What's slammed? Well, obviously you can take someone's head and hit it so hard once that they could lose consciousness or die, could fracture their skull. Or through resistance or something else, you might not be as successful as you want to be, but you still have impact, and it's evident that George Zimmerman's head impacted a hard surface like concrete. Indeed, the state's consulting expert agrees that his injuries, the lumps on his head, are consistent with his head having impacted concrete. We have a medical examiner. He's an eminent, distinguished pathologist. His name is Vincent DeMaio from Texas. He's the expert on gunshot deaths. But he's also a qualified pathologist in trauma, and he'll tell you the same thing. Yeah. He had his head banged pretty hard on cement. That shakes things up. It affects thinking. It can lead to concussion or, of course, depending on how significant the trauma, death. But when you get your bell rung, stuff happens. So, George Zimmerman, a little after midnight, the police make the call. The call is this: we're not going to keep you at the police department. We're not going to arrest you yet. We're going to sort this out first. He had the injuries, the pictures, the statement, the diagrams. So they decided to let him go home. So he did. He and his wife, Shelley, and their friend, Mark Osterman, went home to Mark Osterman's house, as I recall. Mark Osterman is the federal air marshal that I mentioned, who has been a licensed law enforcement officer forever. He's the guy that rides on the plane, undercover, if you will. So that happens a lot, by the way. There's lots of federal air marshals on the planes that we take in light of the horrors that we've experienced with air disasters. So, George Zimmerman decides to go to work the next day to tell them that he wasn't going to be able to go to work. His wife, Shelley, had attended to some of his injuries. She was a nursing student. The swelling had gone down, bandaged it up, and Mr. Zimmerman went to work to check in. He worked at the time and had worked for a while at a company called Digital Risk. Pretty big company. In fact, they're huge now. They do loan investigations or forensic examinations of loans. I don't understand it, but I think what happens is if there are defaulted loans, they ask this company to look into it and see if there's any obvious monkey business. Was there monkey business by the applicant or maybe by the mortgage company? And see if there's something that they can do to back out of someone having to pay off this defaulted loan. So that's what he was doing. It was a paperless job, lots of people working around him, and he liked them, they liked him, they cared for him, remarkably, none of them knew he had a gun, except for one guy that used to be a police officer. And he went in. When he was seen by Laura Williamson, she was stunned at his appearance. She described him as emotionally and physically beaten. He tried to tell her a little bit about what happened, and he was crying. He teared up. She was powerfully moved by that. He was waiting to talk with Ron Driggers. Ron Driggers was the HR person that Mr. Zimmerman wanted to talk with to say, I've been in this event, I'm going to the doctor. Mr. Driggers also saw the injuries, the black eyes. You know, that doesn't happen immediately. The black eyes, all of that stuff that was going on, bandages and such. And Mr. Zimmerman then did go to the doctor. He went to the Altamont family practice and spoke with a physician's assistant that had seen him, named Lynn Folgate. Mr. Guy mentioned her. And she examined him. She thought the nose was probably broken, although there wasn't a clear septal deviation. There was no urgent need to see an ENT, but she recommended it. She noted the lacerations and noted some back injury. Mr. Zimmerman had mentioned that he had fallen on his back or was knocked to the ground and hurt his back, and such. They didn't have an x-ray machine there suitable for the nose, so no x-ray was taken. It was suggested, as I mentioned, that he go to see an ENT. He didn't. He continued to heal and continued to cooperate. In fact, later that day, he met with the Sanford Police Department for this video reenactment that you've heard about. And the next day, and as many times as they asked. I said that we would talk about the physical evidence in the case. Well, we've already talked about some physical evidence, but let's talk a little more about the forensic evidence. While witnesses can certainly be...
A good time to take a recess? Okay, ladies and gentlemen, we're going to recess for lunch. Lunch is waiting back there for you, and we will be back. It is at 1:30 to proceed. In the meantime, if you'll please put your notes face down on the chairs, Deputy Jarvis will collect them and lock them up during our lunch break. During the lunch recess, please do not discuss the case amongst yourselves or with anybody else. You may follow Deputy Jarvis back into the jury room. Please be seated. After we finish with the opening statements, we'll have a brief hearing on the sequestration of the witnesses' issues, so please be prepared to do that. Court will be in recess until 1:30. Be seated. Good afternoon. We're on the record. Well, let me wait a moment. Good afternoon. We're on the record, case number 12 CF 1083A. And Mr. West, as soon as you're ready, we'll get the jury back in and
Yes, Your Honor.
Wanted to address the issue of 9616 before.
I wanted to do it
or
after,
Finish it? Yes, Your Honor.
after openings, yes. Okay, we'll bring the jury in.
Your Honor, the jury is present.
Please be seated. Welcome back, ladies and gentlemen. While you're getting your notepads and selves settled in, I'm going to ask you the questions again. If your answer is yes to any of my questions, please raise your hand. During the lunch recess, did any of you have any conversations amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you. Mr. West, you may proceed.
No more bad jokes, I promise that. I'm convinced it was the delivery, though. I really thought that was funny. I'm sorry if I offended anyone about that. Mr. Guy made several statements to you this morning that were passionate. They were obviously passionate. They were said strongly, but without much detail to back it up. My focus is on the detail, and if I have to sacrifice passion, it's not because I don't feel passionate about this case. It's been my life's work for the last year. But it's because I don't want that to get in the way, even if it means it's boring or somewhat technical. I want the information before you that you may consider in evaluating the evidence. I want to talk with you about specifics. The thing that Mr. Guy said so passionately, but yet so wrong, is that George Zimmerman pressed the gun into Trayvon Martin's chest. Before we broke, I said I wanted to talk about forensic evidence. I do want to talk about forensic evidence because that's science. You can hold your hand around it. You can examine it. It's not subject to bias if the experts are qualified. It's real. It doesn't change. So here's the science around the gunshot. It's fascinating, I submit. The hole in Trayvon Martin's hooded sweatshirt was a contact shot. You will know that because the fabric is somewhat shredded. The undershirt, he had a second shirt on. The fabric on it was also somewhat shredded. That's how a ballistics expert can tell, among other more scientific tests, I suppose, that it was a contact shot. What that means is that the muzzle of the gun was in contact with the fabric. So instead of a hole, a nice clean hole that you would get if you shot from a distance, the gases exploding, the hot gases, burning gunpowder, all of that tears a big hole in it. Contact shots, be they in fabric or be they in skin, are not very hard for an expert to know. It's an obvious call. Not going to be any dispute about that. The shot in the clothing was a contact shot. Why that is so fascinating and so important is this. The bullet hole in Trayvon Martin's skin was not. It was a very round hole made by a bullet. It had, they call it the ring and abrasion, and it had a 2x2 area of soot or stippling or tattooing, 2x2, something like that. And what that means is this. As the hot gunpowder that's burning exits the muzzle of the gun, it burns whatever it hits. It leaves marks. That's why they call it the tattooing or the stippling. It's not gunpowder that wipes off. So with the 2-inch by 2-inch area of this stippling or tattooing, and it not being a contact wound, that means this irrefutably. That the clothing Trayvon Martin was wearing was separated from his skin by at least a certain amount, an inch or 2 or 3. Maybe not can tell that precisely, although I suspect that you can get pretty close with an expert that knows what the 2x2 means, because the gunpowder has to come out and burn. So we have this. We have a contact wound or a contact with the fabric and not a contact with the skin. So then you would say, I would think, how could that happen? Here's how. Just the way John Good saw it. He saw Trayvon Martin straddling George Zimmerman and leaning over him, hitting him or punching him or pushing him. When you lean over, gravity pulls the fabric away. It separates, not like this, but like this. And you might say, well, how could that really happen? We know it did, first of all. But secondly, there's one other big piece of evidence that fits together perfectly that shows that John Good saw these two men in the position at the time. The way John Good described the position they were in when he saw him was the same position they were in when the shot was fired. And that is this. Do you remember the 23-ounce can of fruit juice by Arizona? Do you know where that was? It was in the front pouch. It was in the hooded sweatshirt in the pocket. That's where it was recovered. So in addition, we have not just leaning over, but we have extra weight in the front. We have a mechanism that explains that. Trayvon Martin's leaning over, straddling him MMA style, the ground and pound. George Zimmerman is crying for help. No one's helping. And he's finally able to get the gun out and shoot. And when he does, he doesn't even push it into his chest. He just gets it out enough that it touches the fabric. He didn't push it in his chest to pull the trigger. Even then, he got it out from his right side. You may have seen George Zimmerman writing left-handed. In case you did, he writes left-handed. But he does just about everything else right-handed. The holster is on the right side. That's how he shoots a gun. Has a permit. Has had a permit for a couple of years. Licensed and responsible. But yes, he did have the gun, and thank God. Because at that moment, he was able to retrieve the gun when he couldn't take it anymore, when he'd been crying for help for 40 seconds, when it appeared as though Trayvon Martin may be reaching for it even. After having his head bashed, his bell rung, his nose smashed, he gets the gun. And what does he do with it? He just raises it. That's all. He just raises it. As Trayvon Martin leans over, he pulls the trigger. Now, that matches exactly, scientifically, that the weighted front, the leaning over, the contact with the fabric, but not with the skin. We'll have experts to talk about that, just so you know. If that ever becomes an issue, there will be experts talking about it, including Dr. DeMaio, that I mentioned earlier. Mr. Guy also mentioned that there was no blood on Trayvon Martin's hands at the time of the autopsy. That's somewhat curious, he points out, isn't it? In fact, though, at the scene at Twin Lakes there, Mr. Martin, of course, was on the ground. You'll see the pictures of him on the ground with his hands on the ground. You will know that one of the things that could have been done would have been to put bags over the hands. That's just a procedure so that the evidence is preserved, so whatever on there doesn't get wiped off or washed off or come off because it comes in contact with another surface. In this instance, maybe even the bag that Mr. Martin's body was placed in. That didn't happen. And when Mr. Martin was autopsied, the medical examiner did not photograph the palms of his hands to see whether there's blood on it or not. There are no photographs that they took that would show one way or another. There's no way to know, is that something that was there that got wiped off or didn't? Something that might have been seen even by staff but not noticed or particularly cared about because there weren't any obvious injuries to the palms of Mr. Martin's hands. Again, we don't have pictures. The pictures of Mr. Martin's hands that we have are only there to show the injury. The injury on this knuckle, a 1/4 by 1/8 abrasion, a fresh abrasion on his knuckle that we would offer evidence is consistent with him striking someone with his left fist. Would it have been George Zimmerman's nose? You'll have to figure that out as you hear the evidence. Could he have scraped it on the sidewalk as he bashed George Zimmerman's head? You can figure all of that out when you get the rest of the evidence. But that was the only injury to Mr. Martin other than the gunshot that the medical examiner noticed. Bruising is a little trickier because, as we know, Mr. Martin was shot in the heart, and he died very quickly. We'll talk to the experts whether one would expect bruising necessarily on the knuckles. I don't believe there was any specific testing done or any, what would you call it, a resection or something. I don't think that was done. But we'll find that out too. But there were no other injuries. No cuts, abrasions, that stuff. But back to the hands, because this is intriguing. One of Mr. Guy's statements was that Trayvon Martin was shown and seen at the scene with his hands under him clutching his heart. I will give you that the picture shows Mr. Martin's elbows out like this, and his hands may very well be under him in that picture. And indeed, it's maybe possible that he was even clutching his heart. But keep in mind this. If Mr. Martin was clutching his heart or had his hands anywhere near his heart where he was shot, there would be blood, wouldn't there? If the medical examiner had done that part of the job. So to say there's no blood in his hands really can't be true. It sounds more like the medical examiner not bagging the hands, maybe not paying particular attention, or perhaps even washing off blood just didn't connect that up. I submit to you, as you listen to the evidence carefully, that it's not significant, or at least it's not meaningful, it's not helpful in figuring out what happened. There's some DNA. There's some of George Zimmerman's blood on Trayvon Martin's shirt around the waistband. There's some of Trayvon Martin's blood on George Zimmerman's jacket. Not a lot on anyone's clothing. In fact, when you see the photos, you'll see there wasn't a lot of bleeding on the clothing or beyond. The way they were positioned, and by changing positions so quickly, there really wasn't much opportunity for there to be much blood exchange. I think the evidence will show you that. But the absence of biological evidence or DNA doesn't necessarily prove anything. It's like if you touch something, I might leave a fingerprint and I might not, but it doesn't mean that I didn't touch it. There's also an additional problem with the DNA in this case regarding Trayvon Martin's clothing. It was, I suppose, a mistake. It certainly wasn't intentional, but nonetheless, there was a mistake made that may very well have affected the ability of the laboratory to do biological examination, specifically DNA. And here's what happened. We know it was raining. We know that Mr. Martin's clothes were wet. That's evident. In fact, you can see that in some of the pictures from the medical examiner. There's dark spots. They were wet. Everybody says they were wet. When you have wet clothing in a forensic setting, you're supposed to package it in paper to let it dry out, or let it dry out and then package it. You put it in a paper bag, it can breathe, it dries out, and the biological evidence remains intact. If you don't do that, then the biological evidence is subject to degradation. It degrades. And what happened is this. While it was a mistake, the clothing that Mr. Martin had was placed in plastic bags and sealed. It's sort of like putting wet shirts in your laundry bag, tying it up, or putting it in a plastic bag, waiting for a few days, and then opening up. It smelled like that. It's had that strong ammonia odor when something has been, fermenting. Maybe that's the word. The notes of the DNA analyst, his name is Anthony Gorgone, showed that in his notes, that there was a strong odor, mold, ammonia. It's clear that the clothes were packaged improperly. It's not clear, though, what significance that had on the evidence that sort of knowing what you don't know, except it's a problem. It violates the guidelines for technicians in packaging clothing with biological evidence, especially wet clothing. But there is enough DNA to show that these guys were face to face, that there was an exchange. The gunshot proves, by virtue of the contact, that they were less than an arm's length away. That George Zimmerman didn't see Trayvon Martin somewhere over there and shoot him. That they were face to face, basically on top of each other. And the distance between the clothing and the skin shows that Mr. Martin was leaning over, precisely as John Good described what he saw when he walked out and knew it was serious. There's also another piece of evidence, calling it forensic evidence from the medical examiner, that corroborates what John Good saw. This is a photograph that was taken by, I think, Priscilla Feller, I think was her name. She was one of the assistants for Dr. Ball, Ben Dorton and Priscilla Feller. I think she's the one that took the pictures. And this is the picture of Trayvon Martin's pants. And what I'd like to point out to you and ask that you listen carefully about the evidence is the dirt on the knees. We know it was a wet night, rainy night, the ground was wet, and that John Good saw Trayvon Martin on his knees straddling George Zimmerman. This is circumstantial evidence. Remember we talked, I didn't actually, direct versus circumstantial. This is circumstantial evidence corroborating what John Good said. It's direct evidence of there being dirt on the knees. Let's also talk about some of the forensic evidence at the scene, as opposed to at the medical examiner. And just to orient you here, what this is this is a poster board that was created as a result of the information collected through a system called Total Station. The Florida Department of Law Enforcement has it, or at least they did. They can go to a scene, they can set up the unit, and they can they call it shoot. They can shoot all these points, hundreds of points, that allows them to create and recreate exact measurements of where everything is. They can get the buildings, they can get all of this stuff. You can take that data then, and you can put it in a software program and recreate it graphically exactly the way that it was, mathematically exactly. That's what happened here. The fellow that created this, a fellow named Daniel Shoemaker, used the data that the Florida Department of Law Enforcement collected and then took the information from Diana Smith, the crime scene person where everything was found, and put it on this picture. The T, Jenna Lauer, Jeremy Weinberg, John Good, Mr. Manalo is here. There's a couple of things that don't offer much by way of help. A plastic Walmart bag, even the plastic 7-Eleven bag at marker 2, or even marker 4, the first aid kit. They were there in mark, but I submit they're not worth spending a lot of time on here. There are drain boxes and sprinkler boxes noted in exactly the position where they were. And then there's some very specific physical evidence. You'll see pictures of those in the trial, and you'll be able to determine the relationship. Because of the perspective on this, it's a little difficult to know how far this is, but for just our purposes, this from the T to these markers is roughly 30 feet, 30, 40 feet in that neighborhood. Marker number 6 is where Trayvon Martin's body was noted. Marker number 8 is a cartridge case. That's the spent casing. That was the shot, that was the shell casing in the shot that George Zimmerman fired right here. Right nearby was a cell phone that became identified as belonging to Trayvon Martin. There's also a flashlight here. Mr. Guy mentioned 2 flashlights. The evidence would suggest this was a flashlight that George Zimmerman had on him, perhaps in his pocket, but that it didn't work. On the other hand, there's no physical evidence connecting this flashlight to anything. In other words, there's no blood on it. There's nothing that means anything more than it's here. I think if you listen back to the recording of the non-emergency call, that if you listen carefully, you can actually hear some tapping of George Zimmerman trying to get the light to turn on as he's exiting the vehicle. There is a light that did work, though, and it was attached to his key. It was a little tiny flashlight, and when the police got there, they found it, and they found it on, attached to the key, right here. I would ask you to think about that as you hear the evidence, because one of the issues, of course, is where was Mr. Zimmerman going? Was he trying to track down Trayvon Martin? Or was he headed back to his car or somewhere to meet the police? We know from the other evidence that this is where it started. And this is where the key and the little flashlight was found. This is circumstantial evidence, if you will, that this is in fact where it started. Not somewhere down here or somewhere else, but this is where George Zimmerman got punched in the face and dropped his key as he was headed back to his car. There was the fighting, it went on down this way, the screaming, and then John Good saw Trayvon Martin on top of George Zimmerman right here. And when he went back inside, just a few seconds later, the shot was fired. The shot that could only have been fired in this position. There's obviously an important issue about the voice on the recording, the voice that's screaming for help. As I mentioned before, it doesn't seem as though there's a lot of dispute that that's what happened, that someone was screaming for help. So the idea would be, if possible, to learn, certainly valuable to the case, who was that? We know from Officer Tim Smith that when he arrived on the scene and was speaking with Mr. Zimmerman about what had happened, that Mr. Zimmerman told him right then, right afterwards, I was yelling for help and no one helped. So that's evidence. That's evidence that Mr. Zimmerman was yelling for help. He was the one with the injuries, of course. And common sense might suggest that the person yelling for help is the one being injured, as opposed to being the person on the top. But there's more than that, obviously. First of all, a question is, can science tell us who was yelling for help? And the short answer is no. The voice sample was submitted to the Federal Bureau of Investigation Digital Laboratory at Quantico. Their senior scientist is a fellow with 30, 40 years experience named Hirotaka Nakasone. And Dr. Nakasone personally evaluated and reviewed, examined the recording, and said, there's not enough sample here. After you get rid of all of the extra stuff, the masking, people talking over top, noise, and reduce it to just the sounds that could be subject for some scientific analysis, he said there was only about 2.5 seconds, and there was nothing they could do with it. They tried, but there was nothing they could do with it. It's not suitable because of the length, but even more so, it's not suitable because of the nature of the screaming. In voice identification, you can't do a valid voice identification with someone that's screaming. It's either a waste of time or the results are unreliable, is the bottom line. And they know enough at the FBI to say, no, we can't. We wish we could, but we can't. So therefore, there is no scientific voice identification evidence on that. However, there is some things that science can tell us. One of them is, for example, it's accepted in the scientific community that you cannot tell someone's age by screaming. You can't listen to someone that's screaming and know how old they are. Because of what the fear and the panic in a life-threatening situation does to you, it changes everything. There's nothing predictable. A 50-year-old man can sound like a 14-year-old girl. So there's nothing there either that helps scientifically to know whose voice it is. So what we're left with then is people that may be familiar with the voice, and whether or not someone that knows the voice can say, I've known that person their whole life. I've known them in every situation since they were little, laughing, crying, yelling, what have you. And I hear that and I recognize it, and this is who I think it is. And there's evidence about that in this case too. I'll give you an example. George Zimmerman's uncle, Jorge Meza, is retired military and a sworn deputy with the Orange County Sheriff's Office. He was at home working on his computer or something, and his wife had the TV on in the background. Mr. Meza didn't know necessarily what she was watching, except it was the news. And he heard the scream over there working on the computer. He heard it playing on TV. And he will tell you, he immediately, without question in his mind, knew that was his nephew George. Likewise, there are family and friends of George Zimmerman, co-workers, who listened to the recording, either on when it was played in the media or elsewhere, and said, that's George Zimmerman screaming for help. Without naming them all or talking about it specifically, categorically, co-workers, friends, and of course some family. On the other hand, as one might expect, there will be witnesses to say that I've also listened to the recording and that I think that that's Trayvon Martin's voice. I would expect his mother to say that. She certainly wants it to be his voice. I would expect that his father would say that, and perhaps other family members. But I think there's some things to know about that as the evidence unfolds. The event was February 26th, 2012, about 7 o'clock at night. As I mentioned, it wasn't immediately clear who Trayvon Martin was. Mr. Martin and Ms. Green weren't home, and Chad Johnson, the 12-year-old, didn't know something was going on. So it took a while for this to unfold. And then on, I believe it was February 28th, investigator Chris Serino with the Sanford Police Department met with Tracy Martin and Brandy Green. Now, they'd met with them before, but this was at the Sanford Police Department for the purpose of reviewing where the investigation stood and to have the opportunity to play the recordings. I believe Mr. Zimmerman's call may have been played. There were other calls played of other residents that made a 911 call, none of which had the screams or the shot. But there was this one call, the call that we've heard here today with the screams in the background. And Mr. Martin and Ms. Green were sitting at a desk in kind of a bullpen area in the Sanford Police Department, and Investigator Serino was playing the recordings for them and having them listen. And played the one that you've heard here today with the screams and the shot, and played it through from beginning to end. And Investigator Serino then turned to Mr. Martin and said, "Is that your son?" And Mr. Martin lowered his head and said, "No, that's not my son." Brandy Green didn't weigh in on it. She didn't say, "Well, let's hear it again." Mr. Martin didn't say, "Let's hear it again. I'm not sure. I can't hear it very well." Said, "No, that's not my son." Indeed, Mr. Martin didn't tell Sabrina Fulton that he had heard the recording at the police department when he talked with her. And then, of course, more stuff started to happen in town. Things started to happen. George Zimmerman hadn't been arrested yet. There were press conferences. Indeed, after this event at the Sanford Police Department, Mr. Martin and Ms. Fulton hired a lawyer, a law firm, several lawyers, and a media consultant. Began to have press conferences. The community reaction became to building. In fact, there was a lawsuit filed to get the recording released because it was part of the investigation. Mr. Martin did not go back to the Sanford Police Department and say, "Can I hear it again?" His lawyer didn't do that. Ms. Fulton never contacted the police department and said, "Can I listen to the recording?" Instead, there was great public pressure on the city to release these recordings. The state attorney's office in charge of the case, Norm Wolfinger, he's the state attorney for this circuit, was contacted. He didn't want the recordings released.
No, I'm sorry, objection. This is contrary to our motion in limine that we heard last week.
Okay, and it's also a closing argument. Sustained.
Thank you. With this backdrop and the issue of the recordings being in the forefront, there was a meeting held. There was a meeting held on March 16th, I believe, 16th or 17th, where no law enforcement was present or allowed to be present at City Hall. Mr. Martin was there, Ms. Fulton was there, several of their family members were there. including their legal counsel, Mr. Crump and Ms. Jackson. And these recordings were played by the city manager and the mayor. They were basically taken out of evidence without law enforcement being present and played. And not played for each one by one, separate from the others, but were played all at the same time with everybody in the room. Mr. Martin said then, no, that is my son. And of course, Ms. Fulton and the others, powerfully impacted by that, now say that it is too, that that's Trayvon Martin. They have not involved themselves in understanding the evidence of the case, though. They haven't looked at what we've already talked about.
Is closing argument sustained?
So, another person, though, that identified this voice unmistakably as George Zimmerman is Eloise Dilligard. We talked about her earlier. She was George Zimmerman's neighbor. She was the woman, an African-American woman, who saw Mr. Zimmerman's truck and said, I'll ask George. She knows Shelley Zimmerman. She knows George Zimmerman. And when she heard the recording, frankly, given the context of this case, as tough as it might be for her to say that, she said, yes, I know it. That's George Zimmerman. Excuse me. I'd like to talk about for a moment, and I promise I'll be done pretty soon. This is a lot of information. Even though the event itself only took a few minutes, there's a lot to know about it, a lot of very real evidence. And then there are legal considerations as well. And you've already heard part of the instructions on second-degree murder, the elements of second-degree murder. And you've also heard part of the instruction on self-defense or justifiable use of deadly force. The way that gets to you is through jury instructions. The statutes and the rules and such are distilled into a form that's supposed to be relatively easy to understand and instructed. Insofar as self-defense is concerned.
I don't object to this as being an improper opening statement.
Okay, the purpose of opening statement is to give the jury an overview of what counsel believes the evidence will show. Comments on what the evidence was is for closing arguments. The objection is sustained.
Yes, Your Honor, I understand. My point, though, is this. A consideration that you may properly have in a case involving self-defense are the physical abilities and capacities.
I don't object.
Sustained.
Trying to fix it.
Okay. Well, counsel can state in opening what you expect the evidence will show. Any comments on the evidence or the law is for closing argument.
Yes, Your Honor.
Thank you.
May we talk for a moment about the physical abilities and capabilities of Trayvon Martin and George Zimmerman. Mr. Guy suggested to you a couple of things, and I'd like to respond and point some things out to you. Insofar as Trayvon Martin is concerned, he was 5'11", around 160 pounds. He was a former football player. He used to play linebacker, and he was very good at it. He knew how to give a hit and take a hit, as anybody does that plays football. He also knew from John Good's testimony that he knew how to mount someone so as to incapacitate them. Mr. Guy mentions that George Zimmerman had some training too. Yes, let's talk about that for a moment. George Zimmerman, some years back, was quite heavy and wanted to get in better shape, lose weight. Regrettably, after living in hiding the last year, following this event, he's put it back on. But in February 2012, he was considerably lighter than he is now. He was around 200 pounds. And it was a result of diet and exercise, which I'm told is the only thing that ever works when it comes right down to it. He worked full-time, as I mentioned. As Mr. Guy mentioned, he also went to school. He was in college. And when he could, he went to the gym. The gym is called Cocapelli's Gym. It's in Lake Mary. The guy who runs it is a fellow named Adam Pollock. Adam Pollock is a skilled boxer. I think he was a professional fighter at some point. Understands martial arts, was a corner man in fights. When people get hit and hurt, they fix him up. In fact, he saw George Zimmerman within a day or so of this event in February 2012 and saw the injuries of George Zimmerman being struck. But Adam Pollock runs the gym. He knows, because people pay him each month, who's current. He doesn't know, though, who goes and when they go. Although he teaches some of the classes, he doesn't keep attendance, but he knows George Zimmerman was there regularly and that George Zimmerman was accomplishing his goal. He was losing weight through diet and exercise. George Zimmerman was fitting in the classes that he could, not because he had a special interest in anything, but because it accommodated his busy work schedule and school schedule. And they included a grappling class, and a boxing class. In the boxing class, as Adam Pollock will tell you, George Zimmerman never made it past standing and hitting the bag. Adam Pollock considers him to be not athletic, and Mr. Pollock knows an athlete when he sees one, not skilled. He uses the vernacular soft, that George Zimmerman is soft, and that he never considered letting him get in a ring with anybody. Did he go to class? Yes. Did he say even to Lynn Folgate, yes, I do this kind of exercise, this Muay Thai martial arts thing, but not because he was any good at it. You'll be allowed to consider that evidence too when you look at the physical abilities and capabilities of the two individuals involved in this. One of the things that is important, of course, is responsible gun ownership. I told you a little bit about the evidence about George Zimmerman being a responsible gun owner. There's no evidence whatsoever from any of the people that the FBI or FDLE interviewed that George Zimmerman was trigger happy, that he was reckless. In fact, most people didn't even know he had a gun. He didn't brag about it, didn't tell people, didn't show it. But he got a permit in 2009. They lived in this community since 2009, and there was a neighbor that was not a responsible dog owner. Had a big dog, a powerful dog, and an aggressive dog. And the dog would get loose, the dog would come into the backyard and harass people, including George Zimmerman's wife. And like a responsible citizen would do, the animal control was called a couple of times. The dog was still not on leash, and the owner wasn't being cooperative. So what do you do when you've got a big, aggressive dog that's not on the leash? Pepper spray? That was an idea that Mr. Zimmerman considered. You get pepper spray, but that doesn't work. You don't have enough time, and you're probably more likely just to make them mad. So what do you do about it if you're in that situation? If you're living in a community like that, you only have one choice. You either make yourself vulnerable or you get a gun. And if you get a gun, you should get a license.
Objection, Your Honor. Again, I'm going to object to this as being improper.
I'll
Sustained.
rephrase. George Zimmerman got the permit, took the class, learned how to use the firearm responsibly, was good friends with Mark Osterman, the air marshal told you about, who told Mr. Zimmerman what kind of gun to get for personal protection. You want a double action only gun without an external safety, because if you need it, whatever that situation is where you really, really need it, when seconds truly matter, you don't have time to think about taking the safety off. You don't have time to think about racking the gun.
Your Honor, again, same objection.
Sustained.
If you're going to have it, it should be exactly the way Mr. Zimmerman was carrying it. So, Your Honor, I would like to address the jury briefly on the burden of proof and the standard of proof.
Judge, I would object to that as being improper for opening statements.
Opening statement is for counsel to tell the jury what they expect the evidence will show. Argument as to the law is for closing argument.
Your Honor, would the
At the close of the evidence, the court will instruct the jury on the law that's to be applied, and counsel at that time may argue how that law applies to the facts. This is opening statement. The objection is sustained.
Would the court remind the jury that it's the burden of the state?
Okay. The court will instruct the jury at the time of when the evidence is closed as to the law that applies to this case.
You've heard some of that already in the jury selection and the general voir dire. about whose burden it is and what the quality of the evidence has to be and what self-defense is.
Judge, again, I'm going to have to impose the same objection. I apologize.
Sustained.
I only ask that you remember that, what you've already known, plus this. If I've heard it once, I've heard it 1,000 times, that Trayvon Martin was unarmed. What the evidence will show you is that's not true. Trayvon Martin armed himself with the concrete sidewalk and used it to smash George Zimmerman's head. No different than if he picked up a brick or bashed a head against a wall. That is a deadly weapon. And the law is very specific about when you can defend yourself when the other person has a deadly weapon. Please listen to all of the evidence. You're going to be with us. We're going to be with you for a while. Maybe not as long as we first thought, a couple of weeks, I hope. And that you understand that the prosecution goes first. They put on their case first because it's their burden. So just keep the open mind, no matter how passionate the opening might be, until you hear all of the evidence. That's all I can ask. Thank you.
Thank you, Mr. West. Ladies and gentlemen, we need to take up a brief matter outside your presence. So if you'll please put your notepads face down on the chairs and follow Deputy Jarvis back into the jury room. Okay, please be seated. And this is, we're going to have a hearing. The case law provides that a hearing should be conducted to determine whether a witness's exclusion from the rule of sequestration for witnesses will result in prejudice to the accused. Mr. O'Mara?
Well, Your Honor, as I mentioned earlier, I thought it might be appropriate to have a relaxation of the rules on both sides, but primarily from my client. The purpose of the rule of sequestration obviously is to make certain that the witness's testimony is not affected by their ability to listen and hear the evidence they're going to hear today before their testimony. In this case, having had the enormous amount of publicity and the enormous amount of information flow that has gone back and forth, I would suggest to the court that any further, quote, infection of any witness, be it my client's family members or any other, is quite honestly minimized. So that's one suggestion I would offer to the court. The second one is that the evidence that, or the testimony that might be infected or affected by listening to other witnesses needs to be something substantive, something that I would suggest is of relevance to the court. To that extent, I would ask if there is such a presentation that can be made, if in fact the state intends to call Mrs. Zimmerman and Mr. Zimmerman, or if maybe this is just on a witness list for the purpose of keeping them out of the courtroom. And to the extent that that exists, and my client's right to a fair trial, we have to date been very cautious about how we present both sides to the jury. Of course, we've had some concerns with certain members of the church and where they may be seated in the courtroom. We've been very careful with...
Can we please stay on focus?
Because
the rule does not give me... The rule does not indicate at all that any other witnesses on a witness list are allowed in the courtroom except for the victim or the next of kin, the parent of a minor child, or a lawful representative of such person. Does not provide for any other witness. There is some case law that talks about experts, mental health experts, and the court has the discretion whether to allow them to remain. There's nothing in there that says family members of the defendant, even if they're on the witness list, are entitled to be in the courtroom. The test is if there's prejudice to the defendant for, at this point in time, whether or not the victim's parents are allowed to remain in the courtroom or their representative. I know that you had objected to Mr. Crump. A court will find, as to that part of it, and I've read the case law over lunch, and in conjunction with the rule says, or a representative. If the family members are going to be in here, then they don't need a representative. So to the extent that the family members will be present during the trial, as long as Mr. Crump is going to be remaining on a witness list, he will not be allowed in the courtroom pursuant to the rules of sequestration. And as far as the victim's parents or next of kin, they are allowed in. The defense has to show some prejudice to keep them out. So I'm wanting to conduct a hearing now on what prejudice would there be to the defendant if they were allowed to stay in the courtroom.
I do not make such an argument as Ms. Fulton or Mr. Martin.
Well, but that's what the case law says. The case law says that the defendant has to first show that will object to their being in there, and then make a showing that there's some prejudice. If there's no showing of any prejudice, then they do stay in. The court would have to weigh what the prejudice is and the rights of the defendant. And there's other safeguards that are put in place based upon the case law. For instance, if the family witnesses have been deposed, then that's a safeguard for them staying in. So if you're saying that there's no prejudice to the defendant for Ms. Fulton and Mr. Martin to be in the courtroom, then that's not an issue.
Mr. Martin presents a more unique situation since, as I mentioned at the bench, Mr. Martin, in fact, threatened or at least cursed at one of my client's family members who was sitting there with a
What is
family
the prejudice?
tag.
Please don't go off focus here.
No.
No, me either. Okay. You need to show me what prejudice to Mr. Zimmerman's right to a fair trial would result if Mr. Martin or Ms. Fulton remained in the courtroom as the next of kin and parent of Trayvon Martin. And whatever you want to present to the court, I will hear the testimony and conduct that hearing.
I will need to get the witness available, not present now, but that witness will testify that Mr. Martin cursed at him as a family member. If he cannot abide by the rules of this court and appropriately conduct himself, then he waives the right to be here as a victim's family member when the mother is here already. So that's my concern if we're talking about Mr. Martin himself. And I'd like some time to get the witness back so we can have him testify to you. But as a proffer of that testimony, that is what happened in your courtroom.
In the courtroom?
Yes.
Because the court has observed today is a full house. Before then, it was not. And I have had the opportunity to observe the family members, friends, press, everybody. And from this court's point of view, other than a few cell phones going off, everybody has been very well behaved, and I have not observed any outbursts, any emotional comments, or any going back and forth. And if that happened, it would have happened when court was in recess. It didn't happen during the time that the court was here. And I will particularly admonish anybody in the courtroom, whether they be a family member, a friend, or a member of the press, that they are not to have any emotional outbursts or any contact with any of the potential witnesses, family members, or anybody else while they're here in the courtroom. So is there any other thing that would be a prejudice?
No, Your Honor. My other argument is that I would like the state to present whether or not they do intend to call my client's mother and father, or if it is literally a facade to keep them under the Rule 9616 and out of the courtroom to offer a more balanced perspective as to my client's family members who wish to support him.
Do you really want me to do that? Because then the state's going to ask you what you intend to do with all of your witnesses.
I'm not trying to. My concern is two witnesses, my client's mother and my client's father.
Well,
If you're
that's a
going to
matter
call
that
them-
I'm not going to require the state to do on the record, but you're free to have a conversation with the state about that, and if it's something you can come to an agreement to, I will, let you stipulate to that. But to try to get into what either side intends to do with any of their witnesses,
A fair
I'm not
trial
gonna
is
go
to be
there.
afforded to my client, and that fair trial is a way to present to this jury an appropriate setting. The setting in this courtroom has now been lopsided in favor of the state through the victim's family
then what
because
are you suggesting, Mr. O'Mara, that I have every member of the public who may have an opinion one way or another be removed from the courtroom? I
mom
don't know.
and dad, both sides. That seems fair to me when I look at it and say, what is fair
The
for this
Supreme
jury?
Court and the legislature, the Supreme Court has determined that a victim's family has an absolute right to be in this courtroom.
That's correct. And I understand that it doesn't say defendant's family, but that you do have the discretion to do so if you'd like.
If they weren't on the witness list, they would be free to be here. If
course.
once they're called and they've testified, they're free to remain in the courtroom. Okay. Anything else on this matter?
I might just have one moment.
Yes, you may. Just for the record, the cases that the court had considered was Gore versus State, 599 Southern 2nd, 978, Supreme Court, 1992. Kane, C-A-I-N versus State, 758 Southern 2nd, 1257, 4th DCA, 2000. And Beasley, B-E-A-S-L-E-Y versus State, 774 Southern 2nd, 649, Florida Supreme Court, 2000. Okay, was there anything else?
Mr. Tucholsky is in the courtroom, so I would call him to the witness stand as to the issue. I thought that he had left because of that occurrence, but he is.
Okay,
present.
Mr. Jakolski, where are you? Please come up here, raise your right hand to be sworn.
Do solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please come up, take the stand. If we could please get the easel down and
I'll get to that in
thank you.
a minute. May I inquire?
Yes, you may.
Sir, state your name, please,
Tim Tucholsky, or Timothy Tucholsky.
and if you would spell your last name.
Tucholski.
And you've heard me mention to the court sort of what I call proffering information, because I didn't know that you were right behind me, concerning an event between yourself and a member of the Martin family.
Yes.
If you could narrate and just tell us what happened and where and when.
I was coming back from a restroom break. I had taken myself. I believe the court was still in session when I came in. When I was walking in, it was just being let out for a break. And Mr. Martin had...
Can you point out the person who you identify as Mr. Martin?
Right there in the blue suit.
Is that a light blue suit?
Light blue.
Thank you.
Had seen me and seen my badge, saying, look, I guess looked at the chest. And right here, he looked down where this was and said, motherfucker, under his breath.
Loud
Enough for me to hear it.
Did you respond in any way?
No, sir.
Did he say anything else?
No, sir.
He was in the courtroom when that happened?
Walking outside the door.
Well-
I was holding the door actually for him and Mrs. Martin and some other
Was
people.
the
that were
judge
coming
on
out.
the bench?
To be honest, I don't know, sir.
Nothing further, Your Honor.
Thank you, Andy Cross.
Hey, Martin,
Yes, you may.
how are you related to the Zimmerman family, sir?
I'm a friend of Mr. Zimmerman.
And was this your first time in court?
No, I've been in courts the last 2 Tuesdays.
Okay, so you pick on Tuesdays to be in court only? Is that
It's
the
the
last
on-
2 Tuesdays?
It's the only time I could get off work to
Sure,
support.
okay. And on the 2 prior Tuesdays, did any other family member say anything to you?
No, sir.
Okay. And well, you're telling us that Mr. Martin, Tracy Martin, all of a sudden, just under his breath, used the word, the language you used, the profanity you used, MF?
Yes, sir, that's what I believe I heard.
It's what you believe you heard, so you're not sure you heard that.
I heard it under his breath.
Well, are you sure or are you not?
I'm sure that's what I heard.
And what other words did he utter?
That's it.
So you were being nice enough to hold the door for him.
I was walking in while he was walking out.
Right, and so you held the door for him, and he looked at you, stared at you, and said, pardon my language, motherfucker, under his
He
breath?
never said pardon my language.
No, that's me saying it.
Oh.
Excuse me. I don't use profanity.
Well, I was walking in, and it was real quick. Like I said, it was under his breath, and it was that word.
So if that occurred, wouldn't he have been concerned that you maybe were going to smash the door in him? Wouldn't it have been concerned that he would be getting out?
I don't know what he's concerned with.
I object. He's badgering the witness. It's a simple statement. Now he's coming up with some fantastical thing that Mr. Martin would think he was going to get the door smashed in his face, and that's why he said it.
Okay, so let's stop this right now. I have told counsel before, first of all, no one talks over the other. The court reporter could only take one person down at a time. I will not have any speaking objections in the courtroom. What is your legal objection?
He's harassing the witness.
Okay, overruled.
Demonstrate to me exactly what you're saying. You were coming into the courtroom, right? And so we're talking about this door right here or the outer door?
The outer door.
Okay, so nobody else saw it except you?
Well, yeah, it was, like I
Right?
said, he was right in front of me here,
Okay.
and I heard,
Right.
I saw him look at me,
Right.
and that's the first time I ever made contact with anybody.
Right. But
on
you're
that side.
saying, so this did not happen actually in the courtroom, it happened outside the courtroom?
It happened between that door and the other door. It was a big crowd of people coming through. I guess it was a break, so a lot of people were coming through. I was coming back.
And you opened the door for him to let him out?
I didn't open the door specifically for him. I was already coming in. I was holding the door because there was a lot of people coming towards me. He was one of the people coming out.
And he went right by you and looking straight ahead, right? He all of a sudden turned towards you.
No, he was, like I said, he was in front of me. He looked down. He was in front of me, coming towards me, looked down at my badge, or my chest area, I'm assuming
Sure.
the badge, and that's when I heard it. Again,
Okay.
that's it.
When he uttered these words, he was not facing you, but he was looking down, correct?
He was looking down. I saw him look at the badge. I can't remember specifics because exactly what happened was, from my view, was he looked down at my chest area and he said that word. That's what I thought I heard.
That's what you thought, so you're assuming that, right?
That's what I heard, and because that's what my ears heard, I'm assuming yes.
Okay, so, but you're saying that Mr. Martin was looking down at and reading your name, and in the process of reading the name on there, George Zimmerman.
As I said, he looked down. He wasn't staring the whole time as you're trying to make, he wasn't staring at me directly in my eyes. He wasn't staring directly down. He glanced, he looked, he said the word, and walked past. And that's all I can tell you.
And there wasn't a threat, was there?
No.
Okay,
That's
so
what
when
I
Mr.
heard.
O'Mara earlier said there was a threat, did you lie to Mr. O'Mara about that?
I never said there was a threat. That's what my specific word, that was the word I heard.
Well, why would Mr. O'Mara have uttered to the court and asserted that there was a threat?
I don't know. I never said threat.
Who did you tell this first to?
I told originally to Shelley Zimmerman.
To Shelley Zimmerman. And she was in the courtroom at the time?
She was sitting in the courtroom, yes.
So this happened before the court got started, before we had the hearing about who could be in the courtroom or not?
Yes, that wasn't today.
So this didn't actually happen today, it happened a prior day.
Yes,
And now you're bringing it to the court's attention?
only because I'm being asked to.
Okay, so I
didn't-
misunderstood. I thought you said it happened today.
I never said anything like that.
Oh, I completely apologize. My fault that I assumed. So it happened last Tuesday?
I believe it was, I can't remember, it was either last Tuesday or the Tuesday before. I think it was the Tuesday before.
So maybe 2 weeks ago, and you waited all this time?
I never waited. I actually told somebody. I didn't want to make a big deal of it because I didn't seem like I should pile anything on to either side right now. So
All right.
I didn't say anything. I was asked,
Sure, okay.
and then
okay.
so I said something.
Okay. And so 2 weeks ago, or maybe later, even longer than that?
No, it's only the last 2 weeks.
Okay,
I've
and
been-
you told who now?
I told Shelley.
You tell Miss Zimmerman, Shelley
Right,
Zimmerman.
right.
What? Did you tell anybody else?
After it happened, and I didn't think it was as big of a deal. Not that it wasn't a big deal. I just didn't want to make any ripples. I didn't want to make anybody sound bad or.
Sure.
So after I told them, I guess they said it might have been a security issue. So I believe some of the deputies were told that it may have happened, or.
Did you go and tell?
I
the
didn't tell
deputy right
anybody
away?
else. No, I discussed it with Shelley and
Zimmerman?
yeah.
Okay, and so you don't know how Mr. O'Mara found out?
I'm sure. I'm assuming through
Okay.
Shelley.
And of course, you're telling us the truth now, right?
Absolutely.
Okay. But it wasn't that important 2 weeks ago, and now it's when you bring it when there's this
Because
hearing about who's.
like I said, I've been asked to. I wasn't planning on coming up here. I don't want to be
Okay.
sitting here.
Okay. Thank you very much, sir.
Okay.
Thank you. Any other questions?
Justin, what is the name, what's on your badge?
It says family Zimmerman, and then the number and then the date.
Okay, thank you. You may go ahead and take your seat. Are there any other witnesses from the defense?
I can call security concerning it, but they found out and instituted a policy that people have
Okay,
to
my
have.
question is, are there any other witnesses?
I don't think they
Okay.
need to know that.
The court's ruling is going to stand, and I'm going to cite again the case of the state of Beasley versus State of Florida, citation previously given, which states there are two bases upon which a defendant may object to the trial court's decision not to apply the rule of sequestration to a witness who is the victim's next of kin. First, one could argue that the witness has changed key testimony to conform to the evidence presented, and counsel had indicated that that was not a concern, and the court has asked if depositions of the next of kin or the family members have been taken, and the answer was yes. The second area of concern may be the prejudice potentially caused by emotional reactions of the victim's family members. And again, the court has stated that there have been no such emotional reactions from the victim's family members while this court was in session for this court to observe. I do not find the testimony that we just heard to be of any concern to the court, but especially with the court admonishing everybody, as I have, that there'll be no emotional outbursts and no comments to other people. With that ruling, with that determination, the court rules that Ms. Fulton and Mr. Martin may remain in the courtroom. While they're here, Mr. Crump will not. As long as Mr. and Mrs. Zimmerman remain on the witness list, they will not be allowed in the courtroom until they have completed their testimony or otherwise been released. Do you need a few minutes before the state calls its next witness?
We need to change out the laptop, and I think the lectern.
Or calls their first witness, I should say. Yes, let's go ahead and get the court ready. How long do you need?
No more than 5 minutes.
Okay, court will be in recess for 10 to make sure we have enough time. Please be seated. Court is back in session. Are we ready to bring the jury back in?
If you could just test your lights one time. I think buttons 3 and 4 are the two we're supposed to hit to demo.
Okay, that's 4.
That's perfect. That'll work.
Okay, so when you want them, you'll tell me and I'll press 4 and then 1 brings them back up.
Yes, ma'am.
Thank you.
Judge, also, we have met with the defense and agreed upon, at this time, I think 163 exhibits, 1 through 163 on the court's evidence list, as well as some others, for example, 184. So, with the court's permission, I will just be referring to them by the number as opposed to the letter, as my understanding is the defense has no objection.
Okay, so 184 is coming into evidence as 184, or would it be as 164?
Well, Judge,
Yes, uh-huh. Okay, well, the reason I want to keep it straight is because if you've stipulated through 163, what you're indicating would be number 184 is actually marked as U for identification. So if the other exhibits between 163 and that exhibit aren't entered, we're going to have going back to the jury 1 through 163 and then 184.
I understand the court's concern. My anticipation is that they're all going to come in.
Okay.
And
Well,
so-
if we're missing somewhere, if we're out of numerical order, so there's no objections then to 184 coming into, or you coming in as 184?
That's correct.
Okay. It will be so marked. Anything else? Okay, anything else from the defense?
No, thank you.
All right, let's go ahead and bring the jury in.
Jury's present, Your Honor.
Please be seated. Everybody have their notepads and pencils ready? Okay, the state will call your first witness, please.
Chad Joseph. Chad Joseph, please.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I repeat it?
No, you have to say
Yes or
yes,
no.
sir.
Yes.
Okay, thank you, sir. You may proceed.
Thank you. Good afternoon, sir. If you'd please tell the members of the jury your name.
Chad Joseph,
Mr. Joseph, how old are you?
15.
Are you in school?
Yes.
What grade were you in this past school year?
8.
In February of last year, 2012, did you live here in Sanford?
Yes.
What neighborhood did you live in?
Retreat at Twin Lakes,
And what was your street address?
2631 Retreat Reef Circle.
Who did you live with in February 2012?
My mom,
And what is your mother's name?
Brandy Green.
Did anyone else live with you and your mother back in February of 2012?
No.
Were you in school in February of 2012?
Yes.
Where did you go to school?
Sanford Middle,
And what grade were you in then?
7.
Did you know a person by the name of Trayvon Martin?
Yes.
And how did you meet Trayvon Martin?
By Tracy.
Tracy Martin?
Yes.
Is that Trayvon Martin's dad?
Yes.
All right. And how did you come to know Tracy Martin and Trayvon Martin?
That's my mom's boyfriend.
Tracy Martin is your mother's boyfriend?
Yes.
All right. Prior to February 2012, had Trayvon Martin ever been to your residence before?
Yes.
And how would you describe your relationship with Trayvon Martin?
Good.
Were the two of you close?
Yes.
Specifically, let me turn your attention to the afternoon of Sunday, February 26th of last year. Was Trayvon Martin at your residence that afternoon?
Yes.
And what were the two of you doing?
Watching TV and playing a game.
And when you say playing the game, what do you mean?
PS3.
Video games?
Yeah.
All right, and PS3 is PlayStation 3?
Yes.
Were your mother or Tracy Martin home that afternoon, that Sunday afternoon?
No.
At some point in the early evening or the afternoon, did Trayvon Martin leave your residence?
Yes.
And where did he go?
To the store.
And how did Trayvon Martin get to the store?
He walked.
Did you go with him when he left your residence?
No.
Why not?
Because I was playing the game.
Did Trayvon Martin ask you if you wanted anything before he left for the store?
Yes.
And what was that?
Skittles.
Is that what you told him?
Yes.
Had you ever been to the 7-Eleven store closest to your residence when you lived in Retreat at Twin Lakes?
Yes.
And have you since seen an aerial photograph of the 7-Eleven store and the retreat at Twin Lakes complex?
Yes.
Mr. Joseph, let me ask you to turn your attention to that screen, and Your Honor, if you would, dim the lights. Thank you. State's Exhibit 1, do you recognize that to be an aerial photograph of the retreat at Twin Lakes?
Yes.
Can you describe for the jury where the main gate or main entrance is to that complex?
Top middle.
And if I were to circle it, is that the main entrance?
Yes.
All right, can you describe for the members of the jury where the back entrance is?
Bottom right.
Bottom right. Okay, and have I circled that as well?
Yes.
All right. Tell the members of the jury, if you would, where was your residence approximately?
Coming in from the back gate to the right on the left, the first building.
All right. And would that be the one that I've circled?
Yes.
All right. That's where you lived with your mother in February 2012?
Yes.
Let me show you State's Exhibit 2. Do you recognize that as an aerial photograph of the retreat at Twin Lakes to include the 7-Eleven store?
Yes.
All right, and is the 7-Eleven store appropriately marked in State's Exhibit 2?
Yes.
To the left of the screen within the circle?
Yes.
All right. Your Honor, you may raise the light. Thank you. Do you recall exactly what time it was when Trayvon Martin left to go to the 7-Eleven?
No.
Did Trayvon Martin have a cell phone with him that afternoon when he left to go to the store?
Yes.
Did you ever call Trayvon Martin after he left to go to the store?
Yes.
And what phone did you use to call Trayvon Martin?
My phone.
Did you have a cell phone?
Yes.
In 2012, February, what was your cell phone number?
407-692-7801.
All right.
01.
Let me say it a little bit slower. 407-692-7801?
Yes.
Okay. Did Trayvon Martin answer his cell phone when you called him?
Yes.
And did he tell you what he was doing?
Yes.
What was that?
He was on his way back.
Did he tell you anything about the weather conditions outside?
That it was raining.
Did you speak with Trayvon Martin on that phone call for a long time?
No.
Was it actually a very short call?
Yes.
After you hung up the phone with Trayvon Martin, did you ever see or speak with him again?
No.
What did you do after you got off the phone with Trayvon Martin?
Watch TV, play the game.
And when you say play the game again, are you referring to the PlayStation 3?
Yes.
Where were you playing video games within your residence?
In my room.
And is your room on the first floor or the second floor?
Second.
And does your room face the back grass area of your residence or the street, Retreat View Circle?
The street.
Did the PlayStation 3 game system that you were using have headphones?
Yes.
Can you describe those headphones for the jury?
Covers your ears.
And were you using those headphones that evening?
Yes.
At any point that evening, did you hear anything that sounded like an argument or a gunshot from outside your residence?
No.
Did you ever go outside your residence that evening?
No.
Did you ever recall looking outside your residence that evening?
No.
Did Trayvon Martin come home that night?
No.
Did you try calling Trayvon Martin's cell phone again that evening after you had spoken with him the first time?
Yes.
And what happened when you called his cell phone?
No one answered.
Did your mother, Brandy Green, and Tracy Martin come home that Sunday evening?
Yes.
And were you still awake when they got home?
Yes.
Did you go to bed after your mother and Tracy Martin came home?
Yes.
The next day, Monday, February 27th, did you have school that morning?
Yes.
Did you go to school that morning?
Yes.
And did you learn at some point that day that Trayvon Martin had been killed?
Yes.
When did you learn that?
After I came home from school.
And who advised you that Trayvon Martin had been killed?
My mom and Tracy.
All right. Thank you, Mr. Joseph. Your Honor, that's all I have.
Okay, thank you, Cross.
Afternoon.
Good afternoon.
Just have a couple of questions. You had said earlier that you were watching TV or playing the games with Trayvon Martin.
Can you repeat that?
Yeah, were you playing on the video games with Trayvon Martin?
Yes.
Was he on the phone much while you were playing those games?
I don't remember.
Do you ever remember him being on the phone at all?
I don't remember.
I'm sorry?
I don't remember.
Okay. But as you were playing, was he playing the video games with you, or was he ever on the phone while he was playing the games?
He was playing the game with me.
Okay. And if we were to look back and say that he left the apartment about, let's say, 6 or so. Well, you don't need to know it exactly. Let's say he left about 6. About how many hours had you and he been playing video games?
I don't know.
Approximately?
I don't remember.
I'm sorry?
I don't remember.
Do you recall how many of those hours of the day you were watching TV with him?
No.
Not at all? Were you either watching TV or playing games with him that day?
I was playing games.
Okay. Was he there with you?
Yes.
And was he playing games as well?
Yes.
Okay. You know the area right behind your apartment there, what we sort of call the dog walk? I'm not sure if you call it that, but that pathway that leads between the two buildings?
Yes.
You know what I'm talking about?
Yes.
Okay. You know where the little dog station is at the end of it?
Yes.
You know where that is?
Yes.
Have you ever walked that from your backyard there, sort of down to that walkway?
Yes.
But how long, just guess for me if you would, how long do you think it would take you to walk that?
I don't know. I don't know.
Do you know about how far it is? Okay. Let me ask you this. You were stepped outside the backyard of your house to the walkway. Could you haul a baseball and get it to the dog, that little dog station?
Yes.
Okay. Softball?
I don't know.
Football?
Yes.
Okay. Thank you. Nothing further, Your Honor.
Thank you. Any redirect?
No, Your Honor, thank you.
May Mr. Joseph be excused?
You may.
Thank you very much. You are excused. Please call your next witness.
Andrew Gall, please.
You solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
You may proceed. Yes, you may.
Good afternoon, sir. If you'd please tell the members of the jury your name.
My name is Andrew Gall.
Mr. Gall, where do you live currently?
Can you have him spell his last name for the record, please?
Yes, ma'am. Would you spell your name, please?
G-A-U-G-H.
All right. Can I get you to scoot up just a little closer to that microphone? Thank you so much. Where do you live currently?
I live in Deltona, Florida.
In Deltona, Florida is located where relative to Sanford?
East Sanford.
And approximately how long have you lived in the Deltona area?
Roughly about 17 years.
And how old are you?
I'm 20 years old.
Are you employed at this time?
Yes, sir.
Where is it that you work?
I work at Rent-A-Center. Rent-A-Center.
And what is it that you do for Rent-A-Center?
I'm a customer account representative.
All right. Let me turn your attention to February 2012. Were you employed at that time?
Yes, sir.
And where were you employed?
7-Eleven.
What was your position with 7-Eleven?
I was a cashier.
And how long were you employed with 7-Eleven?
About a year.
Were you assigned to a particular 7-Eleven store in February 2012?
Yes, sir.
And where was that store located?
Off of Reinhardt Road.
Judge, if you could dim the lights just for a moment. Let me show you State's Exhibit 2. Have you seen that aerial photograph before?
Yes.
All right. Does the aerial in States 2 accurately depict the location of the 7-Eleven located off of Reinhardt Road?
Yes.
You want the lights back on?
Well, I'm going to need you to turn them off one more time. That's up to the court. I've got just a few questions in between. Thank you. Let me turn your attention then to Sunday, February 26th of last year. Did you work at the 7-Eleven on Reinhardt Road that day?
Yes.
And what were your hours?
4 to 10.
AM or PM?
4 p.m. to 10 p.m.
All right. Was there anyone else employed at 7-Eleven working your shift with you?
No, sir.
All right. And was that 7-Eleven store equipped with surveillance video cameras?
Yes.
Do the surveillance cameras capture images inside the store?
Yes.
Are there any surveillance cameras outside the store?
No.
And have you seen footage of your store from the evening of Sunday, February 26, 2012?
Yes.
Specifically, have you viewed footage from that evening of a young man who purchased an Arizona drink product and a bag of Skittles candies?
Yes.
Were you working the register for that particular purchase?
Yes, sir.
Did the young man pay for those items with cash or credit or what?
Cash.
Do you recall any conversation that you would have had with that customer?
No, sir.
Was there anything about that customer that caused you any concern?
Nope.
Did you know the young man who purchased the Arizona drink product and the Skittles?
No.
To your knowledge, had you ever seen him before?
No.
All right, Your Honor, at this time I would ask to publish States 184.
You may do so.
And Ms. Walton, if you could just pause it right there. All right. Mr. Gaw, looking at the frame, can you describe for the members of the jury where the cash register is on the screen?
To the left.
All right. Is it going to be this area that I've put in the semicircle?
Yes, sir.
All right. What is at the front of the frame? What would you see if you walked to the front of the frame?
Candy, gum, chips.
All right. Is the front door also at the front of the frame?
Yes.
All right. As we look in the back, is that the back of the store?
Yes, sir.
Okay. And you've seen this before. Is the customer that bought the Skittles and the Arizona drink product the gentleman walking through the store right now?
Yes.
All right. And the time, is that reflected in the bottom left-hand corner of the screen?
I'm sorry, can you repeat?
Is the time of day reflected in the bottom left-hand corner of the screen?
No.
The 18:22:09, is that not the military time?
Oh, I'm sorry, sir. Yes.
All right. And so that would be 6:22 p.m.?
Yes, sir.
All right. Very good. If you would continue playing that. Mr. Gaw, is that you walking behind the register?
Yes, sir.
Mr. Gall, it appeared that the gentleman who made the purchase picked up something off the floor before he left the store. Do you have any idea what that was?
No, sir.
Do you have any idea if he actually picked something up?
No, sir.
All right. Ms. Walter, if you could bring up one of the other camera angles. Mr. Gall, are there multiple camera angles within that store of the register?
Yes, sir.
Yes?
Yes.
Okay. For example, on this camera view, is that now, again, looking at the counter area?
Yes, sir.
All right, if you'd go to another one. In this view, is this actually from behind the counter, essentially over your shoulder, looking out over the cash register?
Yes, sir.
All right, and the last one. And again, is this also a view of the area behind the register?
Yes.
All right. You know, that's all I have for Mr. Gall. Thank you.
Thank you. Cross?
If I might, I was going to have Mr. Gall, I want to take part on the state's laptop, but I was going to have all 4 views shown, so I may as well do it now. I probably know how to do it, but if it's okay.
Judge, Ms. Walter will be happy
Anything
to
goes
assist.
wrong with it, I don't want it to be my fault.
Start from the beginning.
We saw the first one, so if you start with number 2, that'd be great. Actually, if you would go to the, I'm sorry, we do need to see this one as well, thank you. Did you? Thank you very much, that would be enough then. Thank you, I appreciate the help. If I might inquire, Your Honor? Thank you. Mr. It's Gaw, correct, Mr. Gaw?
Yes, sir.
Great. I note that in the beginning, when the person who we now know to be Trayvon Martin came in the store, that you were towards the back of the store. Was there any reason for that?
Yes, sir.
What was that?
I was doing the temperature checks on all the coolers.
Okay. And then you came up to the register, and we'll talk about that in a minute. And then after Trayvon Martin went back towards the back of the store, I noticed that you went back around the counter and seemed to be either watching him or having a conversation with him. Do you recall that?
No, sir.
You don't recall why you would have done that?
I usually go to the back room after I take care of customers.
In the video, you seem to not go to the back room. You seem to come right around the counter and stop where he was by that front cooler. You don't recall any reason for that?
No, sir.
Okay. When Mr. Martin came up to the counter, did you have any concern over the time it took him to get the right change, to get money out of his pocket?
No.
Do you remember any of this?
No, sir.
So when you mentioned a moment ago that that was Trayvon Martin who purchased the Skittles and the Arizona fruit juice, that you don't remember this event at all, do you?
No, sir.
So you're just sort of answering because you look on the video, and if we tell you that that was Trayvon Martin and that that was the transaction, then you would concur with that, but you don't remember anything, right?
No, sir.
Okay. May I approach the witness for a moment, Your Honor? Sir, if you can just stand up and come out of the witness box for a minute. Maybe just right here. What type of shoes are you wearing? But say it out loud. Just regular heels?
Yes, sir.
How tall are you?
5'10".
Okay, thank you. Presumably you were 5'10" a year ago as well, right?
I'm sorry?
You were the same height about a year ago?
Yes, sir.
Thank you. No further questions, Ron.
Thank you. Any redirect?
Just briefly. So the bag that you put the drink can in, would that have been a 7-Eleven plastic bag?
Yes, sir.
Thank you, sir. Judge, that's all I have.
Okay, thank you. And Mr. Gall, be excused.
You may.
Thank you. Thank you very much, sir. You may be excused. If you'll please call your next witness.
Thank you, Your Honor. Sean Knopke.
solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may proceed.
Thank you, Your Honor. Mr. Nofke, if you would, first thing I'd like you to do, spell your last name for our court reporter.
N is in Nancy, O, F is in Frank, F is in Frank, K-E.
And since Sean has more than one spelling, give us that one too, please.
S-E-A-N.
Mr. Nofke, if you would, briefly introduce yourself to the ladies and gentlemen of the jury. Tell them how long you've worked, where you work, and what you do.
I'm a 911 operator with Seminole County Sheriff's Office, and I have been there for 6 years.
And you said the Seminole County Sheriff's Office. Do you work in what's called the Communication Center?
Yes, sir.
And does that Communication Center handle calls only for the Seminole County Sheriff's Office?
No, sir. Also, Sanford Police Department, Altamont Springs, Castleberry, Longwood, and Oviedo now.
Now, you mentioned also that you are a 911 operator.
Yes, sir.
Does the Communication Center also take calls that are to a line other than 911?
Yes, sir. Non-emergency lines.
Okay. And do you handle both those types of calls?
Yes, sir.
How many people sort of do the same thing you do?
In the same room at the same time, approximately 30.
Okay. And is there a distinction as to what types of calls each person handles, or do y'all just kind of catch whatever comes in?
Say everything, everyone handles everything.
So you're not assigned to a particular shift to only handle 911 or only handle 9-emergency. You handle whatever comes in when it's your turn.
That's right.
Okay. And typically, what sort of shift do you work?
I work typically night shift, overnight till 2 a.m.
Tell me a little bit about what sort of training you have to help you do your job.
It was approximately a month and a half to 2 months of training on the job with a training officer that sits with you, listens to your calls, and makes sure you're doing everything right.
And these calls, when they come in, they recorded?
Yes, sir.
Okay. And do you also write summaries of them?
Yes. Yes, sir.
Were you working on February 26th last year, 2012?
I believe so.
Your Honor, if I could approach? Yes. Thank you. Show you what's already been stipulated to State's Exhibit 173. It's a composite exhibit with a audio recording as well as a writing. Do you recognize those?
Yes, sir.
What's that?
This is the recording of the non-emergency call I took, as well as the printout of the screen that I typed up.
And when you say the non-emergency call you took more than one that day.
Yes, sir.
All right, this is the one that has to do with this case, right?
That's right.
Mr. Nofke, before I get into going through that phone call, tell us a little bit about how those calls come in and what you do when you get them.
The lines ring into our computer system that shows what line they are, if they're a 911 line or one of our non-emergency lines. Then it's as simple as, there's no rotation, it's just answer as you go.
Okay. And this particular call, was it a 911 call or a non-emergency call?
It was a non-emergency call.
And when you got that call, what is it? Do you have a particular way that you are trained to handle and get information as it relates to these types of calls?
Yes, sir. Typically, at the beginning of the call, with non-emergencies, you address the caller with the agency name that the line is being recorded and your name as well.
Do you have a sort of way to refer to the urgency of the type of call you get?
Yes, we do. Based on the situation that's given, we have policy standards that we follow.
Okay. And tell me a little bit about how you distinguish and what you do to note the urgency level you ascribe to each call.
We have signals, and we actually have the urgency of the call. We have our own set standards. With this kind of call, it was routine. Those calls are generally anything non-emergency, nothing life-threatening, or over with crimes. Then you also have priority, which is anything in progress and typically a physical fight or just occurred robbery. And then you also have urgent, which is typically anything with a weapon or where a loss of life could immediately happen.
Do you have a place on your written summary where you assign the priority that you have given to this particular type of call?
Yes, sir.
And could you tell me where it is and what you call it, what it looks like?
Yes, it's at the top. It's the event type, and this was coded as routine.
Okay. How do I know that from looking at your summary, for example?
Right at the top, it says it's the total. The whole thing is 13 PIR.
And is there a section where you designate the priority for the call?
Yes, sir. That the R is what stipulates that. R for routine.
Do you use numbers sometimes too?
Yes, sir. That's for the signal to tell you what type of call it is.
Okay. And what type of call did you designate this signal as being?
This was a 13P, which is a suspicious person.
Okay. And how about a category 1, 2, or 3? You familiar with what I'm talking about there?
Yes, sir. With this would have been a 3. That also just states that it's a routine call. 2 for priority, 1 for urgent.
All right. Explain for me the difference between priority and urgent.
Priority is anything just occurred with just occurred theft or robbery, or anything with a physical fight. And urgent is anything with a weapon or where immediate loss of life can happen.
When these calls come in, do you attempt to figure out who's calling?
Yes, sir.
All right. Now, I understand that some calls that come into your call center have an automatic caller ID function and some don't. Could you tell us what the difference is?
Yes, our 911 system has caller ID. If it's from a cell phone, it doesn't give you a location, but it gives you their callback number and the cell tower it hits off of. If it's a landline, such as a residence or a business, it'll show us the exact address and the city that it's coming from. Non-emergency does not have that function.
Okay, so non-emergency, you actually have to ask the questions.
Yes, sir.
And do you do that as soon as you can?
Yes.
Your Honor, with permission, I'd like to publish States Exhibit 173, the report statement.
You may do so. I turned the lights down, but you don't need the lights.
I don't need the lights down for
Okay.
this. I'm wondering if you turned on the volume too. Because this isn't working.
I didn't touch the volume.
Mr. Knopf, can you get him on a work and change any counter technical difficulties?
Yes, sir.
Sanford Police Department, lines being recorded by Sean.
Hey, we've had some break-ins in my neighborhood, and there's
Judge, I just, I guess, ask the court to inquire, make sure everybody can hear. We've got
Can you hear? Okay. If at any time you can't hear, if you'll indicate that. Thank you.
Mr. Knopf, you recognize your voice there?
Yes, sir.
Okay. And you recognize this to be the call you took?
That's right.
a real suspicious guy. It's Retreat View Circle. The best address I can give you is 111 Retreat View Circle. This guy looks like he's up to no good, or he's on drugs or something. It's raining, and he's just walking around looking about.
Okay, and this guy, is he white, black, or Hispanic?
He looks black.
Did you see what he was wearing?
Yeah, a dark hoodie, like a gray hoodie, and either jeans or sweatpants and white tennis shoes. He's here now. He was just staring.
Oh, he's just walking around the
looking
area?
at all the houses.
Okay.
Now he's just staring at me.
Okay, and he said it's 1111 Retrieve You or 111?
That's the clubhouse.
That's the clubhouse. Do you know what he's near the clubhouse right now?
Yeah, now he's coming towards me.
Okay.
He's got his hand in his waistband. And he's a black male.
Okay. How old would you say he
He's
looks?
got a button on his shirt. Late teens.
Late teens, okay.
Something's wrong with him. Yeah. He's coming to check me out. He's got something in his hands. I don't know what his deal is.
Okay, just let me know if he does
Get an
anything,
officer
okay?
over here.
Yeah, we got him on the way. Just let me know if this guy does anything else.
Okay. These assholes, they always get away.
Mr. Nofke, you asked at one point there to let you know if the person that the caller was watching did anything else.
Yes, sir.
Are you asking, when you have these conversations with people, what does your training tell you about whether you want callers to sort of engage in investigative activity?
Always with us, we're trying to avoid any kind of confrontation. So we ask that in case something does happen so we can immediately update the units.
When you come to the clubhouse, you come straight in and make a left. Actually, you would go past the clubhouse.
Okay, it says on the left-hand side from the clubhouse?
No, you go in straight through the entrance, and then you make a left. You go straight in, don't turn and make a left. Shit, he's running.
He's running? Which way is he running?
Down towards the...
Mr. Nofke, we heard conversation about he's running, and then virtually immediately a chiming noise. Have you heard that kind of noise before?
Yes, sir.
And what did you recognize that to be?
Car door.
Virtually contemporaneous with the comment about running.
Yes, sir.
We heard you ask which way.
That's right.
Okay. Again, are you asking for any sort of follow-up, or are you just asking which way did he go?
Asking which way he went for the officers so we can update them as well.
Okay.
entrance of the neighborhood.
Okay. Which entrance is that he's heading towards?
The back entrance.
Are you following him?
Yeah.
Okay, we don't need you to do that.
Mr. Nofke, we've now heard the comments about these assholes and another comment under the breath there.
Gotcha.
Why did you ask if all of a sudden just bust out with the question about are you following him? Where did that come from, and why did you ask?
It sounded like movement and wind coming through the phone after he stated that the subject was running. So I immediately asked if he was following.
You heard that kind of thing before?
Yes, sr.
Okay. Is that why you asked?
Yes, sir.
And when you said, we don't need you to do that, I'm just going to ask you, how come you don't or didn't say, order the person to stop and don't follow and anything like that? Why did you phrase it like you phrased it?
The reason we do that is because we're directly liable if we give a direct order. So we always try to give general, basic, not commands, but just suggestions.
So do I understand you to be telling us that you would not, as a dispatch or as a call taker, order a person to either follow or not follow?
That's correct.
And that's because you're on the hook for their actions if they follow your order.
That's right.
But you were clear here, it was not necessary for him to follow anything.
That's right.
And the response was okay?
Yes.
Mr. Nofke, I'm still hearing those noises. Is that
Yes, sir.
the same noises that you heard?
That is.
Okay.
All right, sir, what is your name?
George. He ran.
All right, George, what's your last name?
Zimmerman.
And George, what's the phone number you're calling from?
407-435-2400.
All right, George, we do have them on the way. Do you want to meet with the officer when they get out there?
Yeah.
All right, where are you going to meet with them at?
If they come in through the gate, tell them to go straight past the clubhouse and straight past the clubhouse and make a left. And then they go past the mailboxes. You'll see my truck.
Okay, what address are you parked in front of?
I don't know. It's a cut through, so I don't know the address.
Okay, do you live in the area?
Yeah.
What's your apartment number?
It's a home. It's 1950. Oh, crap. I don't want to give it out loud. I don't know where this kid is.
Okay, do you want to just meet with them right near the mailboxes then?
Yeah, that's fine.
All right, George, I'll let him know to meet you with you out there, okay?
Actually, could you have him call me and I'll tell him where I'm at?
Okay, yeah, that's no problem.
You need my number or you got it?
Yeah, I got it. It's 407-435-2400.
Yeah, you got it.
Okay, no problem. I'll let them know to call you when they're in the area.
Thanks.
You're welcome.
Mr. Nofke, what is the purpose of trying to figure out where the caller actually is located?
He said he wanted to meet with an officer, so we need to know where we need to actually send the officer to.
And that went from address to truck to call me?
Yes.
As far as you hanging up the phone,
Yes, sir.
under what circumstances on a call that comes in as a non-emergency call would you, as a dispatcher, sort of stay on the line?
Any call where the actual person or that's causing the problem or any altercation where they're actually physically still in the area or they're still being violent. With this kind of situation, that wasn't the case.
If a caller simply says, hey, can you stay on the line with me?
Yes, sir.
Would you stay on it then?
Yes, sir.
And do I understand that the caller here said to you that to just have the officers call him as opposed to waiting back in his truck?
Yes, sir.
Okay. If I could have just a moment, Your Honor?
Yes, you may.
Thank you, Your Honor. No other questions.
Okay, thank you. Cross?
Yes, thank you. And I'm also going to use your device if I might. Thank you. Afternoon, sir.
How are you?
I'm presuming that when you took this phone call back on the 26th, that it was a routine call for you?
Yes, sir.
You did not know that this was going to become the George Zimmerman case when you first took the phone call, correct?
That's right.
And was there anything particularly unusual about this call? Just in general, we'll talk specifics in a minute.
No, sir.
And of course now, even on the internet, you become sort of a mini celebrity for a moment because you were the one who answered the call.
Yes, sir.
It's been analyzed by hundreds, if not thousands of people, correct?
That's right.
And of course, you've now had a much more focused opportunity to review the tape, getting ready for your deposition here today.
That's right.
Correct? Great. I'm sorry. Deposition. I meant trial. Sorry.
Yes, sir.
Want to talk to you a little bit about that, if I might. And we are going to, I think, have to go through the tape just one more time. So I'm going to do the same. I'm going to let it play a little bit, stop, and we'll chat, okay?
Okay.
Hopefully.
Sanford Police Department. Line is being recorded. Sean.
Hey, we've had some break-ins in my neighborhood, and there's a real suspicious...
We had some break-ins in the neighborhood. You have an opportunity, do you not, to identify the location pretty quickly when you're on the phone with landlines, correct?
Yes, sir.
With cell phones, not as quickly.
No.
Which is why, do you try and get some of the information from the person pretty quickly as to where they are?
That's right.
When getting that information, does that give you an opportunity to look at the situation, the subdivision, the mall it might be in, to identify whether or not there have been problems there in the past?
It does give us the opportunity. It'll show us what subdivision or business name, if there is one.
Okay.
Guy, it's Retreat View Circle. The best address I can give you is 111 Retreat View Circle. This guy looks like he's up to no good, or he's on drugs or something. It's raining, and he's just walking around looking about.
Do you hear any anger in that voice?
No, sir, I wouldn't say so.
Am I already messing up? Oh, then give me 1 second so I can take my junk off that. Thank you. Sorry, Your Honor. Anything in that initial conversation about you, where he says, suspicious person, guy just looks like he's on drugs or something, it's raining. Anything that gave you a cause for concern about the caller?
No, sir.
Okay. And you say, is he white, black, or Hispanic. Is that a standard question for identification of the, I'm going to call him the suspicious person for this purpose, okay?
Yes, sir.
Why do you ask the race?
The officer needs to know who they're looking for.
It's just identification,
Yes,
correct?
sir.
Okay. And based upon your asking that question was when he said to you the words, "he looks black."
Yes, sir.
Right? Did he say that in any way that gave you cause for concern?
No, sir.
Okay. Then you said you see what he was wearing.
sir.
Similarly, you also ask that for identification purposes?
That's right.
That's mainly because if you're going to send an officer, not decided yet, but if you're going to, you want to have that information readily available, because it goes out to the cops pretty much right away, right?
That's right.
Okay, and that's the main purpose of it?
Yep.
Any concern with how he answered that?
No, sir.
Okay, and this guy, is he white, black, or Hispanic?
He looks black.
Did you see what he was wearing?
Yeah, a dark hoodie, like a gray hoodie, and either jeans or sweatpants and white tennis shoes.
Any concern with the way he presented that? Any anger in his voice? Any animosity that you could detect?
No, sir.
You are somewhat trained, are you not? 6 years you've been doing this?
That's right.
Trained, aren't you, to get a good feel for the situation that you're addressing?
Yes, sir.
Because obviously if someone is screaming on one end of the phone, you know that that would be a more immediate concern, right?
That's right.
If somebody's obviously intoxicated on the phone, that would be another focus of yours, right?
That's right.
I've heard stories of people calling 911 to order pizza.
Yes,
right?
sir.
So you have to deal with that stuff as well.
That's right.
So you trained pretty well to filter both in and out of your concern areas, the way people are interacting with you?
Yes, sir.
Were you doing that this day?
I can't answer that.
Oh,
I
just
don't remember.
listening.
Just listening? No.
You were?
I'm
or
sorry.
not?
Yes, sir. Yes, I
Okay.
was.
He's here now. He was just staring.
Oh, he's just walking around the
looking
area?
at all the houses.
Okay.
Now he's just staring at me.
Okay, and so it's 1111 retrieve you or 111?
That's the clubhouse.
That's the clubhouse. Do you know what he's near the clubhouse right now?
Yeah, now he's coming towards me.
Okay.
He's got his hand in his waistband. And he's a black male.
Now, when he said that to you, he's got his hand in his waistband, and he's a black male. What did you take that to mean?
That he had a hand in his pocket.
Anything more than that?
No, sir.
Was he just further describing him that he said he looks black earlier and now he is a black male?
Yes, sir.
Did that cause you any concern?
No.
What would you say he
He's
looked?
got a button on his shirt. Late teens.
Late teens, okay.
Mm-hmm. Something's wrong with him. Yeah. He's coming to check me out. He's got something in his hands. I don't know what his deal is.
Okay, just let me know if he does
Get an
anything,
officer
okay?
over.
You say to him, after he says, he's got something in his hands, yes, he's coming to check me out, don't know what his deal with. You then say, just let me know if he does anything.
That's
okay?
right.
That evidence is a concern that you had for the situation, right?
That's right.
Okay. Because at least at this point, the caller, has he evidenced any anger or animosity yet at this point to the conversation?
No, sir.
Yet he is telling you that he now has a concern about somebody coming towards him, maybe with his hand in his waistband or something.
That's right.
Okay. So, again, based upon your training, was that in an attempt to keep him interacting with you and to find out what else this guy may do?
Yes, sir.
Okay. And then he says, get an officer over here, right?
Yes, sir.
Did you at that point then get to that level, if you will, of getting an officer on the way?
I can't recall that specifically.
Is that identified at all? Let me, if I might, it's now, I believe, in evidence, correct? So if I might show you what's now been released into evidence, is the sheet that goes with it also? It's with him?
Yes.
Oh, great. So I'm just going to have you look at it while I look at mine, and show you on the middle of the page right there where you start talking about how you make entries, correct?
That's right.
And there's an entry in there, isn't there, that talks about the request for police?
Yes, sir.
Okay. Would that have occurred about the same time as this request that you send somebody over?
I can't answer that specifically without the times matching up.
Okay. You weren't here for our little timeline earlier, were you,
No,
sitting in the
sir.
courtroom? Okay. But at some point, nonetheless, they asked for, Mr. Zimmerman asked for you to send a police officer,
That's right.
correct? And then you repeat, yeah, we have him on the way. So presumably you're about the same time that you're getting them there, right?
That's right.
With you telling the caller that?
Yes.
Okay. And then you repeat again, just let me know if this guy does anything else.
That's right.
Now, based upon your 6 years of doing this and just your common sense, if you tell somebody twice to let you know if the person that they're concerned about is doing anything else, do you think they're going to keep their eye on him?
I can't answer that.
You're the one, you did tell him twice to let you know if that guy did anything else.
Yes, sir.
Right? And you're in, would you agree, sort of the authoritative or command position as the operator on the call?
Yes, sir.
You're supposed to be directing the situation as best you can, right?
Without giving direct orders.
Yeah, we'll talk
as
about
well.
direct orders in a second. But you are trained to take situations, identify them fairly quickly, and to resolve them as best you can.
That's right.
And on 2 occasions, you told Mrs. Zimmerman to let you know whether or not this guy does anything else.
That's right.
Okay. It was suggested whether or not that was your intent to imbue or to invest upon Mr. Zimmerman the opportunity or the requirement to perform investigative duties. And I think you said, of course not. Right?
No, sir.
You just told him to keep an eye on the guy.
In case he approached him further and started an altercation, to immediately let me know so I could update the officers.
Okay. Did you intend by that also to keep an eye on him, just to keep an eye on him?
No, sir.
Why not?
It's best to avoid any kind of confrontation, to just get away from the situation.
Then he says these words.
Yeah, we got him on the way. Just let me know if this guy does anything else.
Okay.
That, by the way, is your second time, right?
Yes, sir.
These assholes, they always get away.
Was there any anger in that comment that you heard?
It sounded calm to me.
Okay.
When you come to the clubhouse, you come straight in and make a left. Actually, you would go past the clubhouse.
Okay, it says on the left-hand side from the clubhouse?
No, you go in straight through the entrance, and then you make a left. You go straight in, don't turn and make a left. Shit, he's running.
He's running. Which way is he running?
Now, you've now asked him twice to let you know if he does anything else, correct?
Yes, sir.
And then you say, which way is he running?
That's right.
Now, a moment ago, you said that you might say, tell me what he's doing, because if there's going to be a confrontation or an altercation, you need to know that.
That's right.
I thought you said you weren't going to suggest that he do anything else but that.
That's right.
Based upon 6 years of doing this, do you think that if you ask somebody which way they're running, which way somebody else is running, that they may actually go find out?
Judge, I'm going to object. That's speculation. He's asking what someone else might think based on what he says.
I'm going to overrule because the question, I believe, was what does Mr. Knopf do?
Yeah, what would you think when saying that to someone? I'm wondering if you acknowledge, or if you think that when you say to somebody, which way is he running, that they may actually go check out which way he's running.
My intent was to get a location for the officers to look, but I can understand if someone interpreted it a different way. I can't control the way they interpret the words.
Absolutely, and please understand, I'm certainly not suggesting that you had some responsibility in Mrs. Zimmerman getting out of the car, but because you didn't tell him to get out of the car, did you?
No, I did not.
But you did ask him which way is he running.
That's right.
Now, you said a moment ago that you did hear the concept of a doorbell chiming.
That's right.
Back then, I mean, obviously now, today, we know it, but I'm just really curious if you can think back to when this was a non-event phone call for you, back when it was just very routine. Did you actually even notice the door chiming?
I can't answer that. I
Sure.
don't recall.
Sure, you know it today because
Yes.
we've had a year and a half of listening to it. But back then, the chiming didn't mean anything to you, did it?
I can't answer that one way or another.
Okay.
Down towards the other entrance of the neighborhood,
Okay. Which entrance is that he's heading towards?
the back entrance.
Again, at that point, you're asking for more information from Mrs. Zimmerman
That's
to
right.
know who turns out to be Trayvon Martin was heading.
That's right.
You wanted to know which way he was heading,
That's right.
in what direction,
Yes.
towards what entrance,
Yes, sir.
and what path.
Specifically for the officers to know where exactly to look for
I'm
this
sorry.
person.
No, my point was, you also wanted to know what path he was taking, correct?
That's right.
Okay.
Are you following him?
Yeah.
Okay, we don't need you to do that.
Okay.
Now, that's where you suggest that you can't give a direct order,
That's right.
but certainly you can tell someone to stay in a house, right?
It's not that simple with, you don't want to give direct orders to someone. You can make a suggestion for their safety.
If somebody is on the phone with you and there's gunfire outside and
Yes, sir.
cops are involved, and someone says, I'm going to go out and check out what's going on, you're not going to order them to, I know we can't use the word order,
Yes.
you're not going to tell them to stay inside?
I would also tell them, we don't need you to go outside, just stay where you are.
Okay, so is that sort of just the way you have to say it so you avoid liability?
Yes, sir.
And Mr. Zimmerman responded, correct?
That's right.
What did he say?
I believe it was okay.
All right. Now, these shuffling noises that we heard a little while ago,
Yes, sir.
would you acknowledge that that's probably wind noise?
Yes, sir.
Okay. And so he gets out of the car, he is talking to you on the phone, and you hear wind noise.
Yes, sir.
There's no suggestion from you, is there, that he was running?
It sounded like his breathing was strained.
Gotten out of the car, and you heard breathing strained over the noise?
Yes, sir.
Okay. And then he said okay, and you still hear the noise?
For, I believe, a few extra seconds afterwards.
Is that the
Yes.
same wind noise?
Yes, sir.
Is that noise simply from having a cell phone outside of a car?
Possibly.
Okay. You don't suggest it's anything else, do you?
I can't answer that.
Okay. Just curious because you're the one listening.
Yes, sir.
That's what we're talking about?
Yes, sir.
Okay. Do you hear any breathing sound there?
No.
Okay. So even if you heard breathing sounds before, you definitely didn't hear them just then, did you?
No.
Okay. Suggesting, if I might, that he's no longer breathing heavy?
I have no way of knowing that.
Okay.
George.
I'm sorry.
Okay.
All right, sir, what is your name?
George. He ran.
All right, George, what's your last name?
Zimmerman.
Again, at this point, after he thought Trayvon Martin ran, did you hear any anger in his voice or any upset?
No, sir.
Anything that caused you any concern for how Mrs. Zimmerman was acting throughout all this?
No, sir.
And you're still trying to get
Hey, George,
information.
what's the phone number you're calling from?
407-435-2400.
And this is more of a curiosity. I thought you had his phone number.
We always have to ask for it, whether we have it or not.
Okay.
But on this type of call, no, there's no caller ID on the non-emergency lines. So we
Okay,
do
so-
have to ask for it.
Gotcha. So non-emergency, cell phone, you don't get the number that shows up.
That's right.
911, you do,
You do. But you
And-
also have to verify it as well.
no matter what, make
No
sure you have
matter
it
what,
right.
yes.
Great.
We do have them on the way. Do you want to meet with the officer when they get out there?
Why do you ask that?
Because simply with this kind of call, they don't have to meet with an officer.
Sure.
It could just be check the area for this person, but you always want to ask whether they
Okay.
want to or not.
Makes sense, I guess, since they have the information to relate to the officer?
That's right.
Okay. And is it standard protocol that you give them the option?
Yes, sir.
So had George Zimmerman said no, then there would have been no other phone call, no other meet where or how or when or with whom? And
That's right.
that would have been it.
That's right.
But he said yeah.
Yep.
Did he insist on that?
No, sir.
Yeah.
All right, where are you going to meet with them at?
If they come in through the gate, tell them to go straight past the clubhouse. And
What? Did you hear that?
Yes, sir.
What do you think that was?
I have no idea.
Could that have been, and I'm not certain if you've heard this before on a 911 call, flashlight against a palm, trying to see if it's
That's the
on?
witness is speculative. He's already said he doesn't know.
Sustained.
Did you give me your insight as, let's hear that again. And tell me what you, if you can, tell me what that is.
Yeah.
Said he had no idea.
I'm sorry, let me stop that for 1 second. My concern is that I should have let,
His objection is overruled. You could play it for him again.
yeah, I interrupted. I apologize, Your Honor.
If they come in through the gate, tell them to go
It's that noise.
Yes, sir.
At all, any insight on what that is?
No idea.
straight past the clubhouse. And
Again, any
No idea.
insight whatsoever?
No, sir.
Did it seem as though it was coming from his side of the call?
I can't answer that.
Okay. Didn't come from your side of the call, did it?
I have no idea.
Okay, sorry.
straight past the clubhouse and make a left. And then they go past the mailboxes. You'll see my truck.
Okay, what address are you parking?
Now, in his attempt to identify a location for you to have the officers meet him at, he told you that they would see the truck.
Yes, sir.
Any reason why you didn't ask him for the description of the truck at that point?
No, not that I can recall specifically.
Is that standard protocol that when you're going to meet somebody by a vehicle, you get it identified?
Yes, sir.
And any explanation for why that didn't happen here?
No.
Okay.
Front of.
I don't know. It's a cut through, so I don't know the address.
Okay, do you live in?
It's a cut through, I don't know the address. Do you live in the area? Did you have any concern at that point about how Mrs. Zimmerman was acting?
No, sir.
The area?
Yeah.
What's your apartment number?
It's a home. It's 1950. Oh, crap. I don't want to give it out loud. I don't know where this kid is.
Did that give you any cause for concern that didn't want to give out an address while this suspicious person was still nearby?
No, sir.
Okay, do you want to just meet with them right near the mailboxes then?
Yeah, that's fine.
Now, when he said that, did that seem to make sense to you? Mailboxes were identified location and just meet there?
Yes, sir.
Any concern then when,
All right, George, I'll let them know to meet you with you out there, okay?
Actually, could you have him call me and I'll tell him where I'm at?
Okay.
when he said that, any concern with just having the officer call him?
No, sir.
Did anything go up on your spidey sense or your radar that was problematic?
No, sir.
When we talked about these changes, I think Mr. Manti said something like, from mailbox to truck to call me. I'm sorry, address to truck to call me. Did that give you, the person actually listening, any cause for concern as to how Mrs. Zimmerman was acting?
No, sir.
Yeah, that's all right.
You need my number? You got it.
Yeah, I got it. It's 407-435-2400.
Yeah, you got it.
Okay, no problem. I'll let them know to call you when they're in the area.
Thanks.
You're welcome.
I think Mr. Manti asked as well, did this call seem to rise to a level of concern where you felt the need to keep Mrs. Zimmerman on the call?
No, sir.
Why not?
The person who he saw that was suspicious had left the area, so there was no need for him to follow, and there was no concern for his safety.
Any concern in the presentation that George Zimmerman said, or how he presented to you, that caused you any concern?
No, sir.
Any of the words that he said?
No, sir.
I mean, we hear there that he says fucking punks. Was that something that got your blood rushing in some form or fashion?
No, sir.
You've heard that many, many times in
That's
your
right.
life as a 911 operator?
That's right.
Is cursing, since you do it on a daily basis, is cursing something that you hear in many of the phone calls you take on?
That's right.
Any concerns about these words that cause you any real concern?
No, sir.
How about the idea that he said these assholes always get away?
No, sir.
None whatsoever?
No.
Then you treated this call as many of your others. You'd sent an officer out there. Did you then just move on in your duties?
That's right.
Do you don't keep track of what's going on with calls once you finish them, do you?
I typically do, yes.
Oh, okay. Anything significant about this?
After finding out what actually happened related to other
okay.
calls we got, yes.
Right, because obviously there we will know, as the evidence will present, there were a lot of 911 phone calls that came in from the area.
That's right.
Okay. I might just have a moment, Your Honor.
Yes, you may.
Thanks very much, Your Honor. No further questions.
Thank you. Any redirect?
Please, Your Honor. Mr. Nofke, the caller never identified the individual by name or suggested that he knew who he was, did he?
No, no, sir.
Okay. But yet called him an asshole and a fucking punk.
That's right.
Okay. Does that, Mr. Romero was asking, does it suggest to you any number of things? Does it suggest to you that he had nice feelings and warm
I'm sorry,
thoughts?
Your Honor. This would be redirect still with the rules, so I object to this leading the witness, Your Honor.
Okay. Please rephrase your question.
Does it suggest to you that the caller had nice thoughts or something else?
Leading, again, Your Honor.
Yes, sir.
It suggests calling someone an asshole and a fucking punk?
Oh, no, I'm sorry. No, sir.
Okay.
No,
No. Might it suggest things such as ill will?
Yes.
Objection, Your Honor. Again, leading question, Your Honor.
Okay, we'll rephrase your question.
Sure. Mr. O'Mara discussed whether you had any, whether it elevated, I think your blood was the phrase that he used.
Yes, sir.
You're used to hearing people call each other these things,
That's right.
okay? And the feelings that follow with those words, in your experience, are what?
Hostile.
There was a point where you asked the race of the individual,
That's right.
and you got an answer.
Yes, sir.
What was the answer?
Blackmail.
Okay, he looked black.
Yes, sir.
There was a second point. Do you remember the part where you discussed with Mr. O'Mara, has his hand in his waistband?
That's right.
And then the next phrase was,
I don't recall specifically.
okay. Do you remember being told he's a black male again?
Yes, sir.
Did you ask that time?
No, sir.
And in fact, you'd already heard.
That's right.
And when you said, and Mr. O'Mara asked you, your words to the caller, the defendant,
That's right.
about let me know if he does anything else, remember those questions?
Yes, sir.
Okay, were your words?
My exact words?
Yes.
I don't recall exactly word for word.
Did we hear it on the tape?
Yes, sir.
Did you say, let me know?
Yes.
Did you say, go find out?
No.
Did you say, follow or keep an eye on?
No, sir.
Did you say, go investigate?
No.
I'm going to focus for a minute. This is the part of the tape where we hear the getting out of the car.
That's right.
You go straight in, don't turn and make a left. Shit, he's running.
He's running. Which way is he running?
Down.
Did you hear that?
Yes, sir.
How long was it between he's running, which way he's running, and those door noises?
Immediately.
Okay. So getting out of the car, was that because you asked anything, or was that already in progress?
Object, Your Honor, that would call speculation from this witness.
Sustained.
Does the tape speak for itself?
Yes.
It's all going on right at the same time.
That's right.
Now, you talked about the wind noise versus the running noise. Remember that series
Yes.
of questions? And I guess Mr. O'Mara asked you thought it might be running, I think you said because you also heard some breathing?
Yes, sir.
Okay. There was a point in time where the what you described as wind noise stops. You recall that?
That's right.
Okay. But I guess let me ask you, what clued you into getting out of the car was the noises we just heard, the clicking and the door chimes and that?
Yes.
Did you ever hear anything indicating he got back in the car?
No, sir.
But there was a point in time where the wind noise stopped?
That's right.
And yet the conversation went on?
That's right.
So whatever stopped that wind noise wasn't getting back in a car?
I don't know.
No other questions, Judge? Thank you.
Just a few. So possibly the wind noise may have stopped because he had gone past an opening area to where he walked next to another building and the wind stopped. Would that be a possibility?
A possibility, yes.
Okay, so it could have happened that way, right? He was out in the open, let's say in an area between two buildings, then he walked past the opening between two buildings. When he got next to the second building, the wind stopped?
That's a possibility.
Okay. Did you ever, you knew he got out of the car. I think we now, did you, let's be clear. Because I thought you cleared this up earlier. We now know that he got out of the car because 16 months of all this. But I thought you said back then, with that little dinging, did you even know he got out of the car?
I can't answer that one way or another.
You don't know, right?
Yes.
If you had heard dings and you remembered him back then and thought he got out of the car and asked him if he was following him, right? Because you did do that.
Yes, sir.
Why didn't you tell him to go back to the car?
I had no idea if he was in a car or not.
Well, he told you where his truck was, right?
That was afterwards.
Oh, okay. The hostility that might come from fucking punks. I want to be clear. Did you hear any of that hostility in the conversation?
No, sir.
Okay. So while you may believe that if someone says fucking punk somewhere else, it might be a hostile statement, the hostility was not evident in any of your conversation with Mr. Zimmerman, was it?
No, sir.
Okay. And this part about looking black and actually being black.
That's right.
His first statement to you was, you asked him race, and he said he looks black.
That's right.
Did that seem definitive to you?
No, sir.
He didn't just say he's black, he said he looks black.
That's right.
And then, when he got a better look at him as he was coming towards him, I think with his hand in his waist, he said he's a black male.
That's right.
Did that, to you, just seem like he was confirming the race?
Yes.
Did it seem like he was focusing on saying black twice because he had some racial overtones to it?
I have no idea. I can't answer that.
Thank you, Your Honor. No further
Thank you.
questions.
Any redirect?
No, Your Honor.
May Mr. Nofke be excused?
Yes, Your Honor, subject to possible recall.
Thank you, sir. You're excused subject to being recalled. Thank you. Call your next witness.
Ramona Rumpf, Your Honor.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, do me a favor. Go ahead and spell your first and last name for our court reporter.
Ramona Rumpf, RAMONA RUMPH.
And Ms. Rumpf, where do you work and how long have you been doing that?
Seminole County Sheriff's Office since May 19th, 1987, and I'm the Deputy Director of the Communications Division, which encompasses the custodian of records.
Okay. And the Communications Division, is that what we've heard from Mr. Nofke, is the 911 and non-emergency call center?
Yes, it is.
And when you say you're the records custodian, that sounds like a big job. What is it?
That's maintaining the calls that are received on 911 and non-emergency lines, and also the CAD screens, which is the computer-aided dispatch for documented events.
And how long have you worked there for the sheriff's office?
For 26 years.
And Ms. Rumpf, the nature of your duties, does that involve occasionally having to retrieve and verify records of prior calls?
Yes.
And are these calls documented both on tape as well as in written memoranda that are prepared for records purposes?
Yes.
Mayor, if I could approach. Ms. Rumpf, I'm showing you what is first marked as State's Exhibit 171 and 172, a composite exhibit, and then three more, 158, 159, 160, 161, and 162, 163. Do me a favor. Tell me if you have seen these exhibits and if you recognize them as true and accurate records maintained by your agency and retrieved by yourself.
Yes, I do.
Your Honor, to the extent they haven't been received in evidence yet, I would move those numbered exhibits as into evidence.
Numbers 159 through 163 have been. Numbers 171 and 172 have not. Are there any objections?
No, Your Honor, in sequence, the first ones are the 911 calls, no objections, and then 171 and 172. Thank you, no objection.
No objections? 171 will come into evidence, and so will 172.
Let me first start, Ms. Rumpf, with the distinction between 911 and non-emergency calls. Tell us a little bit about that and what the difference is into how those two calls are treated by the call center.
A 911 call is a call placed at the time of an emergency or the time that the person's deemed that they have an emergency. All of our calls are recorded when the line rings, and a CAD screen is created for dispatch. And a non-emergency call is just that, received on an administrative line, and it is received with crimes that are over with or a crime that is non-life-threatening.
Were you asked to retrieve a series of prior non-emergency calls placed from a particular phone number by George Zimmerman to the call center beginning in August of 2011, extending through the early part of February 2012?
Yes.
And are those represented in, I believe it's 171 and 172 before you?
Yes.
Okay. Are there written documents affiliated with each of those?
Yes.
Okay. And they are also on the disc recording?
Yes.
Okay. If I could, I want to talk a little bit about these written reports that are made. You're familiar with those and the information those contain?
Yes.
All right. I'm going to would you be able to help explain what one of those looks like to the jury and what information is contained on one of those?
Yes.
Okay.
It is, as I stated, a what we refer to as a CAD screen, which is computer-aided dispatch. And that screen is created whenever you call in a complaint, and it is the date and time that is it's time-stamped, so to speak, like you would have on a receipt when a call is received, and we complete the information that the caller is giving us, the location of the event, the type of event, the person's name and phone number, if they're willing to give it, and any additional information regarding that event is obtained at the time of that call.
And Your Honor, could I request the lights, please?
Yes, sir.
Thank you. Ms. Rumpf, directing your attention to the screen up here, and I know that may be a ways to try and see it. Let me ask you in general terms. Up here in the top left corner, is this, for starters, is that what you recognize to be one of the written records that you've just been describing?
Yes, it is.
And up here in the top left corner, there's a phrase called an event number. Would you tell us what that means, please?
An event number is basically like what it sounds. It is associated with an event, and it is created by the system. So it is linked to an event. It's basically what it sounds like, an event number, like a case number, so to speak.
And tell me about the times that are available to the people who keep the records in the call center as far as telling when a particular call connects and disconnects and how that is recorded.
The information is the Annie and Allie information up in the upper left-hand corner, and it gives you the date and time. Annie and Allie is automatic number identifier and automatic location identifier, ANI and ALI. And then it has a minute and second. The next time is the connection time, which is also date and time stamped. And the next time is the created time, which is also date and time stamped.
What's the difference between those two, connected and created?
The connection time is the time that we actually picked up the phone and answered the phone. And then the created time is the time that the person taking that phone call sent that call in, or event added it, sent it in to be dispatched, sent in a call for service.
Down in this section of the report, you start with location and caller name and that sort of thing. Where does that information come from?
That information on this call would have been given to us by the caller, Twin Trees Lane. The
And
caller. I'm sorry, go ahead.
And this particular call, is this a 911 call or a non-emergency call?
That is a 911 call, and you can tell from the call source.
That tells you that right there where I just drew a very bad circle?
Yes, where you drew the very best.
Okay. And is there a priority affiliated with this call?
Yes, it is.
And what is it?
3.
What does that mean?
That is a routine call.
I'm sorry, priority 3 means?
Routine 1, 2, and 3.
Okay. Tell me, how would a 911 emergency call be a routine prioritization, and does prioritization ever change?
Yes, it does.
Okay, tell me how.
Based on the information, like I said, a 911 call can be placed at the time a person deems that they have an emergency. During the course of that call, as information is obtained, that call can be changed or upgraded. So it can start out as a call that's routine. However, the call taker can make that decision to upgrade that call based on the information that is being given to them or the information that they are obtaining from the caller.
And is that what happened with this call?
Yes, sir.
Does that tell us that down here?
Yes, sir.
Okay. Where it says the big word upgrade?
Yes.
Okay. As far as the information that you could glean from this, is there a way to tell whether this call might be related to any other calls or any other incidents?
Yes, it is.
How can you tell that?
If you will look up the screen, so to speak, you will see where it says C event 1671, and that is our way of tying events together. So it's saying that that event was EVD'd, which stands for a duplication, and we used one primary screen at that time, which was event 1671.
Now, Ms. Rump, there were a number of 911 calls placed that night.
Yes.
And were they all essentially, did you determine whether they were related or not?
Yes, I did.
Specifically, the date that was reflected on that one, and I guess on all the 911 calls, at the 26th of February 2012?
That's correct.
I'm going to leave those aside for the moment. I want to go to the non-emergency calls, the prior calls by George Zimmerman to the call center. You're aware of those?
Yes, sir.
Okay. And did tell me the date on the first one of those that you have in front of you. And Your Honor, we can. Thank you.
Thank you. August 3rd, 2011.
That was August 3rd, 2011?
Yes.
And that was placed from which phone number?
407-435-2400.
Can you tell me the priority affiliated with that call?
It was a routine call received on an administrative line, non-emergency line.
And have you reviewed the recording that's in front of you already in evidence?
Yes.
Your Honor, with permission, I'll publish that recording.
You may do so.
Thank you.
Burglarized or robbed today, and my wife always.
Airport Police Department, the line is recorded. Petra.
Hey, our neighborhood got burglarized or robbed today, and my wife, I saw one of the kids that did it, and we see someone that matches his description in the neighborhood right now again.
Okay, and what's your address out there?
I'd rather not give out my address because he's obviously in the neighborhood, but it's Retreat View Circle. You can use 1111, which is the clubhouse.
Okay, so does he live in the neighborhood, or he's just out walking?
I don't know. It's the first time I've ever seen him.
Okay. And what is your name?
My name is George.
And your last name, George?
Zimmerman.
And your phone
Like
number
I
you're
said,
calling from?
407-435-2400.
Okay. And is he white, black, or Hispanic?
Black.
And what's
My
he
wife
wearing?
talked to Detective Walker and gave him a description of the guy we see now.
Okay. And what's he wearing right now?
A white tank top and black shorts, and brown sandals and black socks.
Okay. And is he walking?
Yes.
Okay. And so is he near the?
The back entrance to the neighborhood.
So is it the back entrance?
Yeah.
Just went between the houses.
He just went between the houses to the back?
Yes.
Shoot.
He was looking at the car.
I'm not. Why not?
Don't call. Okay, we'll get an officer out there, check the area.
Okay, thanks.
You're welcome.
Mr. Rumpf, what time of day was that call placed?
At 18:45.
I'm sorry, is that 6:45 p.m.?
Yes.
I'm going to move to the next call, which
Your
would...
Honor, I then would move to strike the testimony and the exhibit unless there's a relevancy to this. I presume it would come.
I asked if there was any objection to the exhibit being introduced, and you said no.
But not to relevance of it. And I hope I didn't misspeak, but I would have presumed that there would have been some...
There was nothing spoken. I asked exhibits, I had announced that exhibits 158 through 163 were already in evidence, and asked you if you had an objection to 171 and 172, and you said no.
You are correct, Your Honor. I would ask you, and I apologize, I thought we were talking mechanics rather than admissibility or relevance. I would ask, I still would move to strike the testimony and the underlying exhibit if on grounds of no relevance. And I apologize if my statement suggested that I found all of these to be relevant. I thought we were dealing with the mechanics.
When I ask if something's being admitted into evidence and the answer is no, and I said it'll come into evidence as, they will come into evidence as 171 and 172.
You're correct, Your Honor.
They're in evidence and they're allowed to publish them. So now you want to object to the two exhibits?
Yes, Your Honor.
Ladies and gentlemen, if you'll please put your notepads face down, there's something we have to take up outside your presence, and follow Deputy Jarvis back into the jury room. Please be seated.
And I truly apologize for the confusion. The objection is that it is not relevant to any material issue in this case. He's being charged with second-degree murder. I don't find any.
Okay,
well,
your
that's all I
objections-
need to say is relevant. Sorry.
Relevance response?
Certainly. Your Honor, we have heard already extensive testimony about prior comments during the evidence that did not get objected to, that being the non-emergency call from the date in question, February 26th. Included in those comments was, these assholes always get away. And I think it is certainly relevant then to meet some of the calls about which the defendant is speaking when he says they always get away. These calls are relevant to establish what it is and the context behind that statement. Number two, Mr. West went to great lengths in his opening statement, and there has also been additional discussion already about the evidence already, the exhibits already in evidence about supposed prior break-ins and prior crimes and that sort of thing in the neighborhood. Again, this shows this defendant's response to what he's complaining about when he calls even on the date in question. It's a 6-month period immediately up to and preceding, and in fact, one of them preceding by about 2 weeks, the incident in this case. So I think it is relevant to show the defendant's state of mind when he makes the call on the 26th to explain what it is he's talking about. And there's certainly no objection as to their authenticity. So that would be, I think they're relevant to prove material facts that have already been admitted and argued about at length.
Response?
Well, the response is, again, the state needs to show that they are relevant to a material issue now. If what they're saying is that these are prior, bad acts of my client, there is a specific provision.
I don't think it's under bad acts.
Okay, so it's not under bad acts.
State of mind.
State of mind. A exception because he's thinking a certain way. I think that they would have to meet a much higher burden than to say that because he said fucking assholes and fucking punks.
No, I think it's what they're saying is because he said they always get away, and
that there have been a lot of break-ins.
There have been a lot of break-ins, and
Okay.
that was brought out in openings.
Absolutely, but why does that make prior events or prior calls, for that matter, relevant to today's proceedings? He said they always get away. If, for example, he said they always get away in some aggressive manner, which was not testified to, the only witness who's testified to this evidence, there may be some connectivity, but without that, what they're really trying to do now, I guess, and I definitely would want to profit, because if you're going to go back and say he's done something 5 or 6 times, it has to be relevant for this court's consideration. Other than that, they're trying to show some, they may not be calling it bad acts, but why are they presenting it if it's not? So what's the relevance? Isn't the real reality that the state carries the burden of proving that my client acted with ill will, hatred, spite towards this Mr. Trayvon Martin at all? So how does, how does anything in the past get brought in if it's not reputation, which it's not, if it's not a prior bad act under some other exception, it's not. So how are they bringing in something 5, 6, 7, 8, 10 months before as having a relevancy to today's proceedings?
I'll spell it out even further if I need to, Your Honor. The relevance is that this defendant, if we have to establish his state of mind, which is an element of second-degree murder, the last time I checked, malice, ill will, spite, and evil intent were all directly related to the state of mind of the accused perpetrator. And also, jury will be instructed that this is an act or series of acts. I think it is certainly relevant to show the defendant's state of mind on this night, whether it relates to this particular victim or not, is brought about by his constant and ongoing frustration over, quote, these assholes always getting away.
So it is relevant. It's relevant to show the basis for his comment, as well as what's been going on. And oh, by the way, it's already been, again, admitted and talked about as far as the defense claiming that there were all those prior break-ins. So let's talk about them then.
A brief response. I think what the state is now focusing on, I want to make sure before I fully respond, that they're trying to get this in under a state of mind, a then existing mental, emotional, physical condition. I think a review of that subsection of the evidence code dealing with the hearsay statement suggests that if they are trying to prove the then, if that's where they're going, they're trying to prove the then existing state of mind, my client's state of mind when making the 911 phone, the non-emergency phone call on the 26th. What they're really trying to do is say, well, let's go back and see that, for an example, you may find out in this call that he was calling about a black male. So if that's what they're going to do, they're going to try and say to this jury that he called them a black male before when there's no connectivity between the two. That's a bad act that they're trying to get in, and that's not state of mind. And if you read the state of mind provision, it's quite limited in proving my client's state of mind on this day. And how do you do that? You listen to the tape. The jury can listen to this tape and decide what his state of mind was.
Actually, Judge, the exception that the state provided for these calls is that they're business records. State of mind is a hearsay exception. They might otherwise qualify, but state of mind is an element of the crime of second-degree murder. They've been arguing that since the get-go and actually read the jury the instruction during voir dire. So the state's doesn't have to meet the state of mind hearsay exception requirement to enter this into evidence. The business records exception does that. It's admissible for that purpose. State of mind is an element of the crime, and therefore this is relevant to establish the defendant's state of mind when he says, these assholes always get away and there have been a lot of break-ins.
Okay. Does anybody have any case law to support their argument?
Well, not anticipating the argument, I don't, Your Honor, but if we wish to recess for tomorrow, I'd be happy to try and go get some. I don't have any to hand you right now because I didn't know where, I thought they were coming in. I didn't know that there was going to be an objection.
Well, there wasn't an objection at first, and now there is an objection, so that's the status of where we are. 90.803 subsection 3 is the then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health, when such evidence is offered to prove the declarant's state of mind, emotion, or physical sensation at that time or any other time when such state is an issue in the action. Prove or explain acts of subsequent conduct of the declarant.
Certainly, the events of February 26th being subsequent to August 3rd.
Okay. Well, I will.
I'm sorry, just
I will go ahead and recess for the day, and we can take this up at 8:30 in the morning and have the jury be back at 9, and we can start that. If you don't mind, are you available to come back tomorrow? Okay, thank you very much. So Ms. Rumpf is available to come back tomorrow. The court will bring the jury back in. We'll recess for overnight and give counsel an opportunity to do the research on this overnight, as will the court, and have counsel back at 8:30 to continue this argument. And as I said, we'll have the jury come back at 9. Is that acceptable to both sides?
Yes, Your Honor, and I'm sorry, I missed the time for counsel to report. What time?
8:30?
8:30, yes, Your Honor.
Acceptable?
Yes, sir.
Okay, let's go ahead and bring the jury back in so I can discharge them for the day.
Jurors are present, Your Honor.
Please be seated. Don't get too comfortable. The matter that we're taking up outside your presence is going to take a little longer, and instead of having you sitting back there, I'm going to recess as far as the jury is concerned for the day. So we will see you at 9 a.m. Tomorrow morning. If you'll please give me a moment, I'll go ahead and give you my instructions. During the overnight recess, you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any electronic device to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, text messages, or social networking pages about the case. Does everybody agree to abide by the court's instructions? Okay, is there anybody who is not going to be able to abide by that? Okay, I'm not hearing anything. With that, you're excused for the evening. Enjoy your evening. Please leave your notepads face down. They will be locked up overnight. Please be seated. Ms. Rupp, you're excused until tomorrow morning at 9 a.m. During the overnight recess, you are still under oath. It's as if you're still on the stand, so you're not to discuss your testimony with anybody. That includes the lawyers. Okay, thank you very much. You're excused until 9. Counsel, is there anything else we need to take up before we recess for the evening? We'll see you, counsel, at 8:30 in the morning. Court is in recess. Have them individually marked.
Yes, ma'am.
So those exhibits that are individually marked need to be given to the clerk. And so do you have exhibits 1 through 163 here with you now?
I can put them on a disc in very short order.
Okay.
And tender it to the clerk.
Marked.
Yes, ma'am.
The clerk's supposed to take possession
Yes.
of any exhibits that are marked.
Yes, ma'am. I will provide a CD before we leave.
The CD is going to be marked as one exhibit. You have them marked 1 through 163. If you have a clerk sticker on them and they've already been accepted, they have to be in the clerk's possession. Do you have them with you?
Not in a hard copy, but I can make a
then,
CD. I'm sorry if I'm not understanding what you're saying.
No, I understand what you're saying, but you've handed me an exhibit list, and you have exhibits, each one individually marked,
Yes,
1
ma'am.
through 163.
Yes, ma'am.
Those have been accepted into evidence. 163 pieces of paper need to be given to the clerk because that's how they're marked.
Yes, ma'am.
Okay, you don't have them with you now?
I don't, but I will get them, within 30 minutes.
The court will make an exception and have them here in the morning. Okay, thank you very much. Anything else? Susan, are you okay? Okay, thank you. Court will be in recess.